wrong. I don't think this, I don't. Right, we're at 9 o'clock. So where's Good morning, members. The sitting is resumed. Members, the committee is currently considering the fast track approvals bill, and the question we are now debating is on clauses 1 and 2, title and commencement.
Serious, this bill. This is not glorious whatsoever. This bill runs fast and loose. This bill runs fast and loose over our environment, over our climate, over our te tiriti obligations, over our community engagement. This bill runs fast and loose over democracy, and I am concerned, Madam Chair. We are in the committee stage of this, and my concern, as I'll mention around the title, is the fact that it was less than 24 hours, it was the same day we went into committee, that this huge amendment paper was dropped for us to deal with. There were 3 more amendments that were dropped as well from the government, which is outrageous and wrong. Now, democracy is at stake in this bill. And that's what I just said. So he just mentioned title, and I mentioned I'm about to speak about the title, so I will. Because the fact of this bill is that it is outrageous, it is wrong, and we need to actually name it for what it is. Madam Chair, I want to support my colleague, Aotearoa Williams, in terms of her amendment paper on the table to change the title of this bill. And I think I agree with her. I think Fast Track Public and Private Benefits Act 2024 is a better name for this bill, because this bill runs roughshod over democracy and over our responsibility in this House to the public good. This bill is around private benefits, and we should name it for that. So therefore, Madam Chair, I support her amendment. I'm going to speak shortly on my amendment, which is around the commencement, but I just want to reflect, because as we consider what the title should be, I really want to bring in the voice of submitters from the Select Committee. And the reason I want to do that, Madam Chair, is because when I say democracy is at risk here, there have been so many spaces where this has been truncated and challenged, and the public has not been able to engage as they should, as a good democracy should. This is running fast and loose, and it is wrong. We had 27,000 submitters on this bill, and only a fraction of those were able to submit on this bill. And the majority of those submitters were against this piece of legislation. So I thought, if we're talking about the title, why don't we use some of the words from the public of New Zealand who actually spoke out against this piece of legislation. There's one I kind of like. It's a bit outrageous, but this is cloak, choke, and destroy bill. When it comes to, I thought that was quite good and quite thoughtful of that submitter, who is concerned about coal mines, is concerned about quarries, is concerned about the challenge to our environment and to our climate. So the cloak, choke, and destroy bill, it could be that. Another submitter spoke about the shortcut bill. This is the shortcut bill, because this is a shortcut for private entities to get things done as quick as they can. So, Madam Chair, I want to say that in the title of this bill...
a point of order, Tim van der Molen.
Thank you, Madam Chair. Now, look, the opportunity to debate through the title section is very much constrained to that title piece and around potentially proposing new amendments, and Speaker's ruling 130(2) makes it clear that they must be serious or objectives amendments, and the comments we've just heard from the member are far from that. They're trivialling.
Yeah, thank the member for the point of order, but title and commencement often does come up with some interesting names, and I've heard it a lot in this House over my time. So we'll ask Glenn Bennett to continue this call. but I will remind people it definitely, and this member has touched on title, albeit people don't like the titles that he's suggesting, but we will keep it very title and commencement focused. Thank you.
Kia ora, Madam Chair, and the reason I am using these titles is because it's members of the public. Members of the public who are speaking out and wanting to say, how do we get democracy right? And in the select committee process, a lot of them spoke and felt like their voices were choked and they weren't able to actually speak out about this bill. The other one I want to mention before I come into the commencement around the title is the backwards off track bill. The backwards off track bill. Again, this was another submitter who came to us and said, let's look at this quite seriously. This actually, and people spoke in the committee stage, in the select committee stage, around the fact that this bill takes us back. Someone said this bill takes us back to the 19th century, and the fact this is legislation that has never been seen before in this Parliament. And we don't want a repeat of the 19th century because of the outrageousness of what went on and the destruction to our environment, to democracy, and to land, quite frankly. So, Madam Chair, I want to commend my colleague Aotearoa Williams in terms of her amendment paper on the table, and would like to consider this to be the Fast Track Public and Private Benefits Act 2024. I want to come to the commencement date, because I have an amendment on the table that I want to talk about, Madam Chair, because currently the commencement, this Act comes into force on the day after Royal Assent. So I want to, in my amendment on the table is here, Madam Chair,
Tom Rutherford.
On this question,
Madam Chair,
now closed.
The question is that debate on this question now close. All those in favour, please say aye.
Aye.
To the contrary, no. The ayes have it. A party vote has been called for. Please, Clerk, conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te ko marima na poti whakahe.
ACT New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
6 opposed.
The ayes are 68, the noes are 55. The motion is agreed. Land Farm's amendment to Clause 1 set out on AP number 144 is out of order as not being an objective description of the bill. Debbie Ngaruwa-Packer's tabled amendment to Clause 1 is out of order as not being an objective description of the bill. The question is that Aotearoa Williams's tabled amendment to Clause 1 to replace approvals with public and private benefits be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for. Please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te ko marima na poti whakaai.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Dr Lawrence Yunan's tabled amendment to Clause 1 to replace Fast Track Approvals Act with Fast Track Decisions Act to be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for. Please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima nā pōti whaka-ai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The motion is not agreed. The question is that Francisco Hernandez's tabled amendment to Clause 1 to replace Fast Track Approvals Act with Fast Track Approvals Process Act be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima nā pōti whaka-ai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The amendment is not agreed to. Land Farm's tabled amendment to Clause 1 is out of order as not being an objective description of the bill. Honourable Julianne Genta's tabled amendment to Clause 1 is out of order as not being an objective description of the bill. Dr Lawrence Yunan's tabled amendment to Clause 1 is out of order as not being an objective description of the bill. Steve Abel's tabled amendment to Clause 1 is out of order as not being an objective description of the bill. Francisco Hernandez's tabled amendment to Clause 1 is out of order as not being an objective description of the bill. Celia Wade-Brown's tabled amendment to Clause 1 is out of order as not being an objective description of the bill. Huhana Linden's tabled amendment to Clause 1 is out of order as not being an objective description of the bill. The question is that Clause 1 stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. A party vote has been called for. Please, Clerk, conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumarima nā pōti whakahei.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
6 opposed.
The ayes are 68, the noes are 55. Clause 1 will stand part. The question is that Dr Lawrence Yunan's tabled amendment to Clause 2 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima nā pōti whaka.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The amendment is not agreed. The question is that Land Farms tabled amendment to clause 2 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for. Please, Clerk, conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te ko marima nā pōti whaka ai.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The amendment is not agreed. The question is that clause 2 stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called for. Please, Clerk, conduct the party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te ko marima nā pōti whakahē.
ACT New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
6 opposed.
The ayes are 68, the noes are 55. The motion is agreed. The question is that Celia Wade-Brown's amendment to insert new clause 2A set out on AP number 145 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. The noes have it. Too late, I've declared. The question is that Glenn Bennett's tabled amendment to insert new clause 2A be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. A party vote is being called for. Please, Clerk, conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te ko marima nā pōti whaka ai.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The amendment is not agreed. I will report this bill with amendment presently. Now, if you can just give us a moment to put some new paperwork on the desk, because as you can imagine, there's a lot of paperwork from that particular piece of legislation. Members, we now come to the Residential Tenancies Amendment Bill. We start with Part 1. Part 1 is the debate on clauses 4 to 20, tenancy agreements, bonds and related matters. The question is that Part 1 stand part. Dr. Lawrence Yunnan.
Thank you, Madam Chair. And good to see the Minister back on a different committee stage, Bill. Welcome back. My first question is on the definition in Clause 4, Subclause 1. Now, Within this, I understand that there has been a new insertion of the definition of what keeps a pet means, and we can discuss that a little bit later. But my first question is, what is defined as pet? Because what I'm seeing here immediately is that pet does not include a disability assistant dog, which has given a specific definition within an act, but it doesn't actually define pet more broadly. And I do apologize, I haven't had the time to check the principal legislation to see if the Residential Tenancies Act 1986 already contains a definition of pet. But I guess with this, the bigger question is, people keep different forms of pet. Is there a scope or some sort of boundary around what that could look like? Whether anything can be considered a pet in this regard, as long as the owner themselves declares that is a pet. So that would be my first question. I'm sure other people will have many other questions on this particular section.
Honourable Kieran McAnulty.
Thank you very much, Madam Chair. I thought I would start by touching on the broader themes around the pet bonds, and then ask specific questions about an amendment that I've put in. I'm keen to understand from the Minister's perspectives what alternatives were explored here. And by way of reassurance, I'll get out from the get-go that we support this part, at least. In general, we don't support the bill as it currently stands, but there are some things in this bill that we are supportive of, and we'll make that clear throughout. Pet bonds are one of those. We take the view that we support measures that will look to make it easier for tenants to have pets. That makes sense for us. We know that it's an issue and that it has been a long-standing one. The question is pet bonds the best way to go about it? We don't know the answer to that, and I don't think that the government does because it hasn't been tried before, but in general we support it because it's worth a go. But I am keen to understand what other mechanisms were considered and what advice or examples overseas did the Minister look at to get a gauge as to how effective a pet bond might be in allowing tenants to have pets. I get the rationale that in having a bond, landlords may be more willing to allow tenants to have pets because if there is any issues that arise from that they have a bond there that they can extract from to cover damage, etc. But I think it's important that we understand the broader work that was done to land on pet bonds and the alternatives that were considered. So speaking on that, Madam Chair, I want to speak to an amendment that I have tabled to insert a new subsection. This is to Section 8, and it essentially proposes an exemption for greyhounds. So we're in a situation where this week the House has unanimously supported a bill through the House that would look to protect greyhounds as the first step towards banning greyhound racing. And what we do know from that is that there's roughly 2,900 greyhounds that will need to be rehomed. And on the whole, there has been a broad level of support for this, but then that support inevitably leads to how we're going to find a home for these dogs. And it's a question that the government is going to have to grapple with, and it's one that the Labor Party are more than willing to work with them to try and find a solution to that. And it's in that vein that I asked the Minister to consider this amendment because it is made in good faith and it is a genuine attempt to try and address that issue. And it seems to me that this is an appropriate way in which to look to solve that. So at the moment, Madam Chair, we have a situation where the bill proposes that outside of assistance dogs, that a bond can be placed by a landlord for any tenant that wants to have a pet. But when we've got a large number of greyhounds about to be seeking a home, we need to also look at ways in which to assist that. And so what this amendment proposes is by inserting a new subsection that a landlord may not require payment of a pet bond for a maximum of one greyhound which was previously engaged in greyhound racing or bred for greyhound racing for a period of 4 calendar years following the assent of the bill. And I'll just walk through the rationale here and the thinking. So we don't want it to be all greyhounds because we want it to be reasonable and try and find a pragmatic way forward. We were concerned that if we just said greyhounds, that would include whippets and Italian greyhounds as well. Now they are quite, what's the difference is a very good question. And look, I'm no expert, but they're not greyhounds. They are, Madam Chair.
Honourable Kieran McAnulty.
Thank you very much. They are kind of like exclusive breeds, you know, they're fashionable dogs. Italian greyhounds are very, very small. Whippets are in between an Italian greyhound and a greyhound. But the point is, Madam Chair, they're not used for racing. And there's no surplus. They are bred commercially and people have them, and that's all good. The point here is to try and limit the scope of this to greyhounds that had been engaged in racing or bred for racing. So any greyhound that was purchased through a commercial breeder wouldn't count. The reason we've put suggested a period of 4 calendar years is because once the legislation passes, it looks like that greyhound racing will wind down by 2026. Now I know with conversations with the likes of SPCA and SAFE and other stakeholders that have been engaged in the debate about this issue, they've indicated that it could take up to 18 months, 2 years to make sure that every greyhound gets a home. And so I thought it would be pragmatic to have a window of 4 years to account for the period from now leading up to when the ban on greyhound racing comes in, and then an up to 2 year period after that to help find a home for greyhounds.
You mixed up your speech notes.
No, I mean this is typical of this government, isn't it? We come with a genuine proposal to try and help the government find a solution to an issue, and Penny Simmons has a go. The thing is, Madam Chair, after those 4 years, pet bonds can come in. So we're not saying it's a ban for the rest of the time, and we're not suggesting that a landlord that allows a greyhound in can't then bring in or request a pet bond after that period. It's just a pragmatic way to try and help home greyhounds. It is proposed in goodwill. We are happy and flexible to work with the Minister. I'm quite happy to have a back and forth throughout this to try and get the details right. We might want to work on the definition. We might want to work on the window, how long that is, whatever they're comfortable with. But the guts of this is that we have an opportunity through this bill and through this clause to assist the government in finding homes for those greyhounds that will no longer be in the racing industry.
Dr. Lawrence Yunnan.
Thank you, Madam Chair. While I am also waiting for the Minister to respond to my earlier question on the definition of a pet, and I want to speak more in depth to that question, but I think first of all, we also would like to support the Honourable Kieran McAnulty's proposal around rehoming of greyhound in light of the bill that went through Parliament this week with unanimous support. And we too have amendment of our own on this matter, amendment paper 218, and which is amendment by Steve Abel, which also says the same thing. So we genuinely would like to ask the Minister to consider either or both of these two amendments seriously. In terms of the pet part, the reason I ask for the definition is that when we are looking at section 16, when it goes to when tenant may keep a pet, more specifically, there is nothing in there on not allowing landlords to prohibit a pet as not being suitable for the property without first providing evidence or relevant evidence that a pet would not be suitable for such a property because of its size or type or premise or other form of prejudice. So we have inserted, we have an amendment paper on this, amendment paper 220, that would prevent arbitrary discrimination based on stereotypes of the type of animal and prevent landlords from using these grounds baselessly. And this is a part of a new 42F that we are proposing. Along the same line of that, this another amendment paper 224, which is also on section 16. And this ties back to section 4 when I'm referring to the definition of a pet. Also clarifies that a pet being not suitable for the property due to propensity for causing damage does not include reasonable wear and tear. Again, I think, for many of us who do have pets, it's a general fact that sometimes your pet, your cat, your dog, whatever, doesn't quite do what you tell it to do and may act up. However, that shouldn't be a reason if it's a genuine wear and tear of the property. So, Amendment 224 on Section 16, which is also part of introducing a new 42F, would also prevent propensity for causing damage to be misused for minor unreasonable wear and tear of a property. So I would like the Minister to provide some clarification or at least some certainty if the Minister isn't going to consider the amendment to give reassurances that pets are not going to be, tenants are not going to be arbitrarily ruled out because the landlord thinks that the pet is unsuitable, and that the tenant isn't going to be unduly punished for reasonable wear and tear just by having a pet. The next point I want to address, Madam Chair, is around the other lack of clarity in terms of the definition. And again, this comes from the definition of a pet under Section 4. Now, in Section 4, the definition of a pet is very specific in terms of what it has ruled out, particularly with regards to does not include a disability assistant dog. However, there is nowhere in Section 8 or Section 16 that talks to whether a disabled person would be ruled out for having a disability assistant dog. So my colleague Ricardo Menendez-March has amendment paper, this is amendment paper 219, which includes a clause to emphasize for the avoidance of doubt that the landlord may not prohibit a tenant from keeping a disability assistant dog, which is not a pet. So I would like to hear the Minister's thoughts on those three amendments as well as my question earlier on the definition of pet.
Honourable Chris Bishop.
Thank you, Madam Chair. Some good questions raised by members so far. Let me deal with them. In terms of first contribution from Lawrence Funan, in terms of the definition of pet, I'm advised that no country, when it comes to tenancy law, defines pet. Basically, it's deliberately left as open as possible because people's definition of pets, members can think through the logistical challenges with that. However, the bill makes it clear that disability support dogs are exempt from the pet bond. So to answer, I think, address his concerns. If you are disabled and have a support dog, the landlord cannot charge a bond for that, and the bill makes that clear. So I think most people would agree that that is the right thing to do, and so that the definition of pet explicitly excludes a support dog, but that the whole point of that is to make sure that a bond can't be charged for it. In terms of the definition of pet, we've deliberately left that open. In terms of his other point around possible discrimination against people on the grounds of what particular pet they have or suitability, I think the key point here for him and everyone to bear in mind is quite a significant change to the law, which is at 42E, particularly 4. So what we're doing is reversing what we have at the moment. So the landlord, if the bill passes, the landlord will not be able to refuse consent to have a pet without reasonable grounds or attach an unreasonable condition to the consent. That is sort of buried in the schema of the legislation, but that is the kind of core operative thing, is that landlords can't now refuse consent without reasonable grounds for tenants who wish to have pets. It's essentially a reversion of the status quo, and so it reverses the presumption. So you're allowed a pet, and you can have a pet as a tenant, and thousands of New Zealanders are tenants, and thousands of them either have pets or want to have pets, and I think members broadly agree with the proposition that we want to make it easier for tenants to have pets, and so we are taking quite a significant step in saying that that's fine. Landlords can only refuse consent with reasonable grounds. In terms of what that means, there will be guidance published by the bureaucracy, officialdom, about some suggested definitions about what reasonable means, but ultimately this will be worked through the tribunal, and there will be cases in which landlords refuse consent and tenants challenge that through the tribunal, and that's appropriate because ultimately they are the arbiter of tenancy law. That's the appropriate appeal authority, so to speak, when it comes to tenancy law. So, and that's completely right and proper. And in fact, the bill makes some other, in other parts, makes some changes to the operation of the tribunal, which is a good thing. So we're comfortable with how it's drafted at the moment. I think we've got the balance right, and I think it will provide a lot of benefits for tenants who want to rent but also want to have a pet. And we know that hundreds of thousands of New Zealanders have pets, and they're a very important part of stability and social life for many people. Friendship, fellowship, mental health, very, very important. That's why we're doing this. And to recognise that pets can cause damage, and to try and incentivise landlords to be encouraging of tenants to have pets, we have put in place that pet bond provision. Now, Honourable Kerry McAnulty asks about what other countries do. The truth is there's a variety of different approaches, broadly in line with what the government is proposing around withholding of, not unreasonable withholding of consent. Some countries give nearly an absolute right to have a pet. Other countries have a slightly softer approach. It varies depending on the law and the jurisdiction. Western Australia, I'm advised, has pet bonds. So we think this is a good step forward. In terms of the Honourable Kerry McAnulty's amendment around greyhounds, we had a good look at it, and I've had a conversation with Mr Abel, who has a similar proposal as well. We've had a good look at it. I can advise the government will not be supporting it, and I do want to explain why. And it goes back to the point I made before around the incentive to take a tenant who wants to have a pet. That the quid pro quo of allowing pets or making it easier to have pets, the quid pro quo is the bond for the potential damage, the extra 2-week bond that can be charged. Madam Chair,
Honourable Chris Bishop.
Just finish this point briefly. The quid pro quo is the extra 2 weeks that can be charged. If you exempt the ability to charge the bond, it may actually be counterproductive and have the sort of perverse effect of incentivising landlords to encourage tenants to have pets that are not greyhounds. Because if you exempt greyhounds out of the pet bond provision and say you can't charge a bond for a greyhound, and look, I know I love greyhounds as much as the member who suggested the amendment does. Well, that's possibly true. I don't have one, so that's a good point. But we thought about it. But I love greyhounds. But
you can get one now.
Well, indeed, and there's quite a few to get. There's a bit going on at our house at the moment, so we might just wait. I'm not sure my family would be too keen on me committing to that on the floor of Parliament. We'll see. So yeah, it may actually be it may be sort of perhaps have a perverse outcome. So we think the better approach is allow landlords to charge pet bonds, and I'm fully on board with his desire and drive to make sure that we rehome those roughly 3,000 greyhounds that will need a home in the next 20 months or so as the industry closes down. So yeah, appreciate the drive. We had a good look at it because it kicked it around a bit, but we won't be supporting his amendment.
Honourable Kieran McAnulty.
Thank you very much, Madam Chair, and I thank the Minister for the response to that. I understand where he's coming from, but I would still like to use this opportunity to try and work through a few things and see if we can find a way through. So it seems to me that the government's position is that what we're proposing will work as a disincentive to landlords. What we're trying to do is incentivise people to take on a greyhound and make it easier and more practical. If the government is concerned around the position that landlords may take, would he be open to any provision that gave landlords, if there were to be damage caused under the scenario we're talking about, where the tenant has been exempt from having to pay a pet bond, that there is also another provision available to the landlord to be able to claim more if there's damage within that 4-year period. So they won't be disadvantaged because they will have the protection and the provision to be able to go beyond the cap of damages. The tenant won't be disadvantaged because they won't need to front up with the bond, but it still preserves the landlord's ability to seek damages. And hopefully that would then address the concerns of the government's outlined, the perverse outcome that is described, because ultimately the landlord would still have that provision available to them if there's damage, but it means that the tenants won't have to front up with 2 weeks' rent from the get-go. Now, I had a few questions around the level of the pet bond and talking about what's in the regulatory impact statement. I'll come to those later, but I will just refer to the fact that it does indicate that for lower income people, this could be a barrier, even if the landlord was willing to take on pets. So if the government was willing to at least explore extra provisions available to landlords solely in this specific instance, we might be able to achieve what we're trying to, making it easier for people to take on a greyhound, but addressing the concerns that the landlords have.
Madam Chair.
Honourable Carmel Sepuloni.
Thank you. I'm going to continue on this and just say that having been on the Select Committee, there was a lot of support for the pet bond provision. However, there were some concerns raised, and I think now's the time to flesh them out a little bit. I am interested in what the Minister was saying about not being able to define a pet, and interested to hear that overseas jurisdictions do not either. And I'm wondering whether tenants will have the opportunity to challenge the landlord charging a bond if the pet is deemed to be such that really damage would not or could not or is unlikely to be caused. I'm thinking about things like a caged bird, perhaps, that is maybe not even kept in the house. But I'm wondering whether a tenant would be able to challenge the idea that they would be charged for having a pet or made to pay the bond if really, when things are weighed up, the pet is not really deemed to be one that is a risk or will cause any damage. The other question comes a little bit off the back of something that Kieran McAnulty was saying, and that is around those families that financially struggle. I wanted to check with the Minister whether or not MSD's housing products Particularly access to support for bonds is going to be extended to the pet bond as well, and whether that will come into effect at the same time that this bill comes into effect. Many of those whānau that Kieran McAnulty referred to earlier, struggle to pay the bond in general, but like many whānau, do enjoy the company, and what is part of their family is actually a pet. So wondering whether MSD has included that in their housing product support. I believe it is a recoverable product anyway. It's something that they have to pay back, but wanting to know whether or not access to bonds through MSD will be extended to pets. I also wanted to touch on the issue raised around assistance dogs and support Ricardo Mendes' amendment on this. One thing that was really clear when we were going through the select committee submissions was that there was real concern that there would not be a differentiation and that landlords would not know the difference between an assistance dog versus a pet, and that disabled people or those that have assistance dogs would get caught up in this. Now, I do recognise that the Part 1 does say not include a disability assist dog within this. However, I think it needs to be restipulated, and Ricardo's amendment 219 goes quite some way to doing that. I think it would provide assurance to the disability community that they're not going to be discriminated against with their assistance dogs and go through the rigmarole of having to negotiate and argue with a potential landlord about their situation and their assistance dog and why it is not to come under the pet bond provision. So those are just a few points that I wanted to make for now, and so if the Minister could respond to those, that would be greatly appreciated.
Madam Chair.
Honourable Chris Bishop.
Oh, thank you, Madam Chair. Just on the last point, in terms of disability dogs, I acknowledge the concern that the member raises around what was heard at Select Committee, but I think it's pretty clear in the bill, and which will become the Act, assuming it passes, and there will be clear guidance issued through MB and tenancy services around that, so we're sort of comfortable with where we've landed there. In terms of MSD, good question. So I am advised that tenants may be able to apply to MSD for bond grants to cover a pet bond or part of a pet bond, an application for recoverable assistance under the housing support products, but bond grants will only be allowed up to a maximum of 4 weeks rent per grant for both the general and the pet bond. So MSD will cover up to 4 weeks of recoverable assistance in total. In relation to Honourable Kieran McAnulty's point, we can have a think about it. I think the key point is just really what I said before, which is we want to get the balance right between encouraging landlords to not look askance at greyhounds because they can't charge a bond. The simplest way of doing that is allow them to charge a bond. I think I appreciate his point that we've got all these greyhounds to be rehomed, but I genuinely think the best way of doing that is this bill, plus a wider community effort, which is a subject of a bigger discussion around the shutting down of the greyhound industry and making sure we can rehome the dogs. And there's a whole lot of other things that will need to be worked through, which I'm not responsible for, although I'm interested in it. Yeah.
Honourable Carmel Sepuloni.
Just as a follow-up, it's quite disappointing that the MSD housing product for bonds has not been extended to cover a pet bond. My understanding is, and the Minister can correct me if I'm wrong, that generally most people will expect to pay 4 weeks bond. That's certainly what I've seen. And so the Minister stating that that can also be inclusive of the pet bond is a little bit disingenuous for those that are in the situation where they need to seek out housing products, because they would then be limited in terms of actually it would be potentially the 4 weeks bond for the house plus the 2-week pet bond, but not actually any additional housing support or housing product support to cover this pet bond. It disadvantages them. Even those that are financially struggling enjoy the company, as I said, of a pet, and I don't think that they should be excluded from being able to do that. This is a recoverable assistance product, so it is something that those families would need to pay back. And so my expectation would have been not that it would just be included in the current housing product provision, but that actually it would be extended to ensure that not only could they pay the general bond, but also be able to pay the cover for a pet bond if they chose to take that up. So I do want to put to the Minister that I am concerned that no consideration has gone to extending that housing product and asking the Minister whether or not this is something that they could turn their minds to, or perhaps something that we might need to look at making an amendment for.
Madam Chair.
Honourable Chris Bishop.
Well, ministers have turned their mind to it and we've decided not to. So we've thought about it, we've looked at it, and we've decided not to do that. So just repeat what I said before, which is that so within the 4 weeks, the pet bond can be inclusive. There's a variety of tenancy arrangements out there, 2, 3, 4 week bond requirements, 1 week, 4 is the max, and there's a variety of different arrangements out there. The status quo for now, or the position as of now, is that the recoverable assistance under the Housing Support Program can include a pet bond, but the max is 4 weeks for both.
Francisco Hernandez.
Madam Chair. And before I begin my contribution, I just wanted to thank you, the Minister, for attending the event that I co-hosted with Paulo Garcia last Thursday evening, the parole celebration that we had with the Philippine Embassy and the Bulwagan Foundation, and their colleagues across the House who also attended. Great. I had a couple of questions to do with Section 14A and Section 16. Section 16 revolves around 42E, subsection 1. My question around Section 14A, which amends Section 26, replacing 6 months with 1 year. I think it's a good change, increasing. My understanding is that Section 26 gives effect to Section 25, which basically enables the tenancy tribunal to give an order to force the landlord to charge market rent if someone's getting overcharged. So it's been changed from 6 months to 1 year. I think that's a good change. I think it's a change that we do support in the sense that it gives the people who've been overcharged more security. But just wanted to explore with the Minister why the change from 6 months to 1 year was a longer period considered. I also wanted to ask about Section 16 and the new section that it creates, 42E subsection 1. It says if the tenant makes a written request to the landlord for consent for the tenant to keep a pet on the premises, the landlord must respond in writing within 21 days of receiving the request. So my first question is that standard days or working days? And the other component of the question is what other days were considered within that? Why was 21 days picked? Is there perhaps an option to reduce the amount of days? Because 21 days seems like quite a long time to wait for an answer for, if you're wanting to keep a pet. So just wanting to make a very short contribution to ask these questions of the Minister. Thank you.
Madam Chair,
Chris
just
Bishop.
very quickly on the question of the 6 months to 1 year. Look, the residential tenancies laws is amended quite frequently, and this is just an opportunity to improve the situation. So more fair, as the member I think acknowledges. So our view was it was a better situation, so we've taken the opportunity. Members will see as you go through the bill, the main thing is the no cause terminations, but pet bonds. But there's a suite of other quite sensible, system changes and pro-tenant moves, frankly, throughout the legislation. So we just took the opportunity as part of the vehicle that is this bill. And I'm sorry, I missed his. I was getting an answer on the first one, so I missed the second part of his question. Just very briefly, what was it?
If the member would like to re-ask, it was around working days.
No, the other one.
Oh, the other one?
What was the other one?
Yeah. It was around the working days, so do you want me to re-ask that?
Yes, and the thing you got onto as well, the last point.
So, my question is around subsection 1642E, about the changes it makes for the written consent for tenants to keep a pet. So if it says, if the tenant makes a written request to the landlord for consent for the tenant to keep a pet on the premises, the landlord must respond in writing within 21 days of receiving the request. My first question was, is that working days or just calendar days? My second question is, what other dates was considered as part of that? Was a shorter period considered? Because, 21 days seems like quite a long time to be waiting on, a reply to your landlord. I think people who kind of make decisions to get pets, they're not taken lightly. So I think it'd be, I am a tenant, but if I was looking to get a pet, I would probably like an answer quicker than 21 days. So keen for an answer on that.
Yeah, Madam Chair.
Honourable Chris Bishop.
It's 21 days, not working days. So to answer that, as to why 21, I mean, is there an argument for 28? Sure. Is there an argument for 14? Sure. You've got to put a number at some point. So there's no science to it. It's not rational in that sense. It's just what we think is reasonable. This provision hasn't been used before. Let's get it into law. And if it, 7 days I think would be too low. You can make an argument for 2. Equally, there'd probably be landlords who would say a month, which is basically 28 days, would be fine as well. So look, let's see how it goes. I mean, this will probably be an iterative process. This is quite a change to New Zealand tenancy law around pets. There will be wrinkles we need to work through as part of that. The tribunal will play a part in that, but also Parliament may have to respond to tribunal rulings as well. So one of the things this bill does, for example, is in relation to smoking in properties, which deals with a sort of somewhat unusual view from the Tenancy Tribunal a couple of years ago. So that'll be a bit of an iterative process. That's totally appropriate. You don't get everything right the first time, so if it looks like we need to go down to 14 days, we're happy to have a look at that. Equally, the feedback may be that you need a bit more time. So there's no science to it. 3 weeks, 21 days. I reckon that's pretty reasonable for a tenant to say, look, I want to have a pet. Landlords are busy people. Equally so are tenants. So, let's just see how it goes. Open to change if it doesn't work.
Timothy Paul.
Thank you, Madam Chair, and thank you, Minister, for your answers. Great to be here. Really keen to have a good, robust discussion with you about this bill. So, because I missed the first part, I'm going to start, but just cut me off if this has already been covered, because thankfully there's lots of areas that we can go into. So, I want to ask a question about the evidential basis behind this bill, because from following this bill through the select committee process, it became apparent to me that it seems like there was a decision that you arrived at, Minister, that you decided no cause evictions coming back to New Zealand, as you do, as you're the Minister.
Just point out as part 2, if we can keep to part 1.
Yeah, I guess the evidence that I'm talking about underpins every part of this bill, so that's...
Okay, well, it's fair to ask about evidence, but if you're referencing things, make sure you're in part 1.
Yeah, okay. So, I guess focusing on the evidence behind part 2, this part in the bill.
Part 1.
I want to understand how you arrived at this bill and what evidence underpins these particular parts that we are discussing currently. Because to me, it seemed like you had an objective that you wanted to achieve, but then it seems that we've worked backwards to find the evidence to create the basis for the bill. And so what I want to understand is, what is the evidence, because in my view, the regulatory impact statement that underpins this bill and these parts was like uncharacteristically not as detailed as other RISs that there have been prepared by the officials, and I felt the evidential case wasn't particularly strong, which is unlike that particular ministry. And so, yeah, I would love for you to stand up and tell us what the evidence is behind it, particularly given that there isn't a lot of support for this bill, with 97% of submissions being opposed, and then is it 53% of property managers and landlords being opposed to this bill as well. So if there's not the support there, not this kind of overwhelming call from landlords and property managers for this, then why was this pursued as a political objective if that evidence is not there? So I think you get what I'm getting at, so I'll give you a chance to respond.
Well, Mr Chair.
Honourable Minister.
The members talking about stuff in part 2 were actually on part 1, but I'm happy to address the point. If we want to do it as all parts and as one. No? Okay, no. Well, okay, well, I'm going to be, well, not really, because you're basically talking about, okay, the evidence for PET bonds, which is part 1, the evidence is really clear, and I think the member would probably agree with me, that there are a lot of tenants who wish to have a pet who can't have a pet. I think most reasonable people realise that's been a bit of a gap in the law. The law's been unclear. Probably most people would agree it's been too hard to have a pet, so the evidence underlying it is that we want to make it easier, and I think most people broadly accept that. And the member wasn't here, but we've traversed the provisions around not being able to unreasonably withhold consent, and the quid pro quo of that being that the ability to charge up to 2 weeks for a pet bond.
Timothy Paul.
Isn't it, aren't you not supposed to mention when a member is and isn't in the House? Isn't that a thing, a convention?
Technically, yes, but it's more for when it's appointed comment. All right, okay, well, I'll take it on board. You are technically right, yes.
Mr Chair.
The Honourable Kieran McAnulty.
Thank you, Mr Chair. So, Minister, I've amended my amendment to try and address your responses, and to be honest, this is exactly how a committee stage should work. So it's really good to see that you are, as you said, at least willing to consider it. So in responding to your concerns that the original proposal might have a perverse outcome, primarily focused on the disincentive that this may prove with landlords who would be less inclined to take on a pet if the bond wasn't there. I get that, there's some logic there. So what I'm proposing is to add wording to the amendment, a new bit 1B. So during this period, the 4-year proposal, after which obviously a pet bond can be issued. So during this period, tenant liability for pet damage caused by a greyhound, as defined above, so those that have participated in racing or been bred for racing, could be extended by up to 2 weeks' rent to account for the lack of a pet bond. So from the landlord's perspective, if they allow a greyhound or a tenant with a greyhound, they actually, if there's damage caused, are able to claim more than they would otherwise to account for the fact that there was no bond. So, in essence, if there's damage caused, the landlord has the ability to claim that. But the exemption of the pet bond allows more people to take on a greyhound without having to stump up with 2 weeks' rent. So you incentivise people to take on a former racing greyhound, and you incentivise landlords to take on those people, allow those people to take on a greyhound, knowing that if there is damage caused, they can claim up to what they would have been able to do if there was a pet bond. And I'm hoping that the Minister will see that this addresses his concerns. It's consistent with the intent of the pet bond. It will assist the government in the challenge that it now has in terms of finding residences for former racing greyhounds. I hope it's seen as a bit of a win-win. Like I say, I genuinely approaching this with goodwill, trying to be pragmatic, happy to work on specific detail. I'm not going to die in a ditch on wording or whatever. I'm just trying to find a way to make this work.
Mr. Chair.
Honourable Minister.
Well, I haven't seen the revised amendment, so happy to have a look at it, see it in its full context. I suppose my point would be, if you exempt former greyhounds from the pet bond rules so that you don't have to, you're not allowed to charge an upfront bond, so that tenants don't have to pay an upfront bond, so that it's more likely a landlord will take on a tenant with a greyhound, or that it was more likely that tenants will go and get greyhounds because they're more likely to be able to have a pet have a home with a pet in them. But then you say at the back end of it, you can charge up to 2 weeks for damage. Why don't you just have a 2-week bond? Because that 2-week bond is meant to cover the damage. So it's sort of, I'm not sure, or maybe I've misunderstood the member's point, but I don't. Why don't you just charge a pet bond?
Mr. Chair.
Kieran McAnulty.
Thank you. So the reality is there's going to be a hell of a lot of greyhounds that need a home. There's going to be people that want to take on a greyhound but can't front up with 2 weeks rent to issue a bond immediately. I know that for a fact because I've had people contact me saying, this is great, I want to take a greyhound, but my landlord won't let me. That's not uncommon, right? That's the whole point of a pet bond. If the rationale is true that if we allow landlords to issue a pet bond, then they will be more forthcoming to the idea of a pet, it actually doesn't address the instance that for some people they won't be able to front up with 2 weeks rent. Now, I actually agree with your argument that in general, if this was a proposal across the board, it's counterproductive and sort of misses the point. I get it. But this is specific for former racing greyhounds and greyhounds bred for racing. We know there are people that would take them but can't afford the bond. We know that there are landlords that would allow them if the tenant pays a bond. Exempting tenants from the bond if they adopt a former racing greyhound deals with that issue. Extending the potential liability if that greyhound causes a damage addresses the potential barrier to a landlord taking it on without a pet bond. I think it's a pragmatic response to both realities. If tenants wouldn't have an issue fronting up with a bond, I don't think there'd be a need for this, but we know that there are people that will. It's in the regulatory impact statement. There'll be some people that simply cannot afford the bond. And so it's logical that if that is a fact, that there will be people that would love to take on a greyhound but can't afford the bond. Yeah. Look, we're not talking about thousands of people here. It might only be a couple of hundred. But when we're trying to find homes for 2,900 greyhounds, this is a practical way to help to get there.
Yeah, Mr. Chair. So I get what he's saying. One practical problem is that the pet bond system won't be operational until late next year anyway. There's a bunch of back-end stuff that MB's in the middle of quite a large upgrade to the tenancy system. It's pretty antiquated, to be honest. As I understand it, the bond system's called Bond 2000, which gives you a sense about when it was built. So it's 24 years old. So credit to the last government, kicked off a process of upgrading. It's probably overdue. Actually, the first stage of it went live a couple of weeks ago, and there's other stuff happening. So the pet bond system won't be operational till probably late 25, early 26. That's okay, but we do have an issue in the next year or so around these greyhounds. So I think we're unlikely to support the amendment. I understand what he's trying to do. What I will give him a commitment on is that there is going to be further legislation around greyhounds, which has been signalled by the DPM next year. So I'm not the responsible minister, but I'm happy to try and facilitate some constructive conversations around how we might look at this issue of rehoming in the context of tenancy law, in the context of that legislation. And it may be that I'm just reluctant to commit to something here on the floor of the House, that we just haven't thought through. That's not a great way to make law. So happy to go away and consider it properly. And if it may be is when we legislate in the new year around greyhound racing generally, which I hope the opposition will support as well. It may be that we can do some, and it may be that maybe other wider changes around tenancies in relation to greyhounds, or I'm getting a little bit ahead of the government and the cabinet here, but it's pretty clear we've got 3,000 dogs to rehome, as the member knows, and we want to make sure we do right by those dogs. So happy to look at it in that context, but I think I'll keep looking at it, thinking about it, but I think we're unlikely to support his amendment, but I acknowledge the issue.
Kieran McAnulty.
Very much. I thank the Minister for the response. I would encourage him to at least seek advice on this now. I thank him for his commitment to consider this later. But just to address his concerns around the pet bond thing not being up and running for a while, that's all good, because greyhound racing isn't set to be banned until 2026. And the proposal in the first part of this is for a period of 4 calendar years to account for that. Whether this is in or not, we're still going to be facing the same problem, but we're certainly going to be facing it in greater numbers from early 2026 onwards as the industry starts to wind down. Now, we don't know how long this debate will go on for. It's possible that you might get advice on this and a response potentially from coalition partners on this before we finish the committee stage. That's possible. And it might be that your officials look at this and go, oh yeah, we can make that work. And then, given the goodwill that was shown in Parliament yesterday towards the greyhound issue, it might be that your coalition partners see the logic in this as well. Who knows? It's worth a crack.
Honourable Carmel Cipollone.
Mr Chair, I just wanted to go back to the issue around a bond support through MSD housing products and my concern that they are not being extended to ensure that pet bonds can be covered on top of the existing general bond. And I'm referring to the regulatory impact statement where it looks at impacts on others, wider government, consumers, etc. It does make really clear in the regulatory impact statement that lower income tenants, including beneficiaries and pensioners, will be disproportionately impacted by upfront costs of pet bonds. So again, still disappointed that no consideration to the extension of the housing product to support for pet bonds to beneficiaries or those on low incomes has been considered. Wanted to make an amendment but doesn't seem to be in scope of this, so unable to do that. Given the Minister has said that the pet bonds won't be up and running for quite some time, I would ask the Minister whether he would consider going away and having a discussion with the Minister for Social Development to see whether or not that recoverable assistance, so they do pay it back, can be included. I'm concerned that actually there are some landlords who have allowed pets already and not charged a pet bond, and so some beneficiaries and those on lower incomes have been able to keep pets in rental properties, but actually that ability is going to decline for them because once this is introduced, yes, it will mean that more tenants are able to keep pets, more in general, but less in terms of those on lower incomes or on benefits, Mr Chair. Also, the other thing I wanted to point to was the submission made by the Citizens Advice Bureau and their comments on the pet bond. So although they were pleased to see that the landlord will have to provide a written response to the tenant's request to keep a pet, and where consent is refused will have to provide written reasons for the refusal, they are anxious, however, about the workability of proposed Section 42F reasonable grounds for prohibiting a tenant form or refusing tenant consent for keeping a pet. They state the broad categories of the premises are not suitable for the pet and the pet is not suitable for the property invite subjective assessment by the landlord. They also state the legislation as drafted already deems these to be reasonable grounds for refusal, but there is no requirement that the decisions about suitability are on reasonable, objective, evidence-based grounds, and they're concerned this could lead to more disputes that require the involvement of the tenancy tribunal. So with reference to that particular section, I would like to know from the Minister, what is the workability of that proposed section? And has he received any advice that this particular section could lead to more disputes that require the involvement of the tenancy tribunal as a result of these changes?
Lawrence Zunan.
I just saw the minister get up, so I was going to let the minister respond first.
I'll let you go first.
Okay. Thank you, Minister. Thank you, Mr. Chair. Now, I just want to go back to something the minister said before regarding the disability assistant dogs and assist dogs, and I thank you, the minister, for mentioning that yes, the bill does make it clear that people do not need to pay a pet bond if they have a disability assist dog. But one thing that the minister said that kind of got me a little bit alert was around the fact that we think that this bill has the right balance. But the problem is that this bill has no balance, because by not including disability assist dog under the definition of pet, nothing in Section 8 nor Section 16 includes it. So if that isn't supposed to be the minister's intention, if we can get the minister just to explicitly state that actually, yes, disability assist dog is not part of the definition of pet, but absolutely that this does include disability dogs, and disabled people should not be discriminated against because of the fact that disability assist dog is not part of the definition, ergo not covered under Section 8 and Section 16. My question to the minister is around the written consent, and I kind of follow on from what the Honourable Kamel Sepuloni said in terms of reasonable grounds. And I think one of the things is, well, two things. Number one is, although in 42F, there's a list of what is considered reasonable grounds, and we're looking at A to F, but there is no mention in this bill on what unreasonable grounds may be. So I think it is important if the minister wouldn't mind enlightening the House and giving a couple of examples of what he considers to be unreasonable grounds for the prohibiting tenants from keeping a pet. So that's my second question. The third question I have is around one of our amendments, and this is amendment paper 225 by my colleague Tamitha Poole, around the list in 42F. Now, one of the other things that I think the Honourable Kamel Sepuloni put in very nicely from CAB is the fact that what is the workability of some of these reasonable grounds. But from my perspective, just going a little bit deeper, what was concerning and we're hoping to address with this amendment paper 225 is the fact that the list is non-exhaustive, because it says include the following, for example. So what is going to go beyond this particular list, which I feel is already quite exhaustive? So what are some of these additional examples that the minister can think of for reasonable grounds for prohibition that is beyond what is listed here in A to F? If there isn't, I would ask the minister to consider the amendment paper which changes the phrasing from include the following, for example, to are limited to the following, and make A to F an exhaustive list. So that is my third question. And I think my last question, sort of, I guess, a consequence of a tenant being denied consent to keep a pet under 42E. We know that there are good tenants, there are good landlords, all of those, but we also do see some horrible cases where landlords do use the power that they may have to deny certain rights to the land, to the tenant, and using the legal system or the tribunal system as a way of doing that. So I want to know what are some of the scope around if a landlord refuses and the tenant challenges that. Yes, 42E subsection 5 and 6 is very clear on committing an unlawful act, but that will only stand if the proposed or the potential tenant take them presumably to the tenancy tribunal. So that is an extra burden again on the potential tenant. So what are some of the mechanisms to prevent some of that? So those are 4 questions for the Minister. Thank you.
The Honourable Minister.
Thank you, Mr. Chair. I think we've sort of covered these issues about 3 or 4 times now. So just very briefly, the member's really worried about the definition of pet in relation to disability dogs. I've addressed this 3 times now, but for the absolute avoidance of doubt, the definition of pet in the bill expressly excludes disability assistance dogs as defined in Section 2 of the Dog Control Act 1996. This is standard drafting practice where a definition typically applies to the entire Act. The exclusion of disability dogs as pets is relevant to the pet bond provisions, the pet consent provisions and the pet damage liability provision. As I've said twice now, guidance issued at the time the bill passes and available online makes it clear that the pet provisions cannot be applied to disability assistance dogs. So we've thought about it, covered it off, I've said it 3 times now. I think we've dealt with that issue. In relation to his points around 42E and F, this is about reasonable grounds. The word reasonable is used in the Residential Tenancies Act over 140 times. Okay? It's the basis of tenancy law, largely. So it's used extensively. Yes, it is used extensively. And at 42F, the member suggests, I think the member suggested at one point that we make the provisions in 42F exclusive and exhaustive. I don't think he actually wants that. 42F includes without limit, so it makes it clear essentially some examples of where a reasonable grounds for prohibiting a tenant from keeping a pet in a tenancy agreement would be. So, and these are things I think most people would think are pretty reasonable. Premises that aren't suitable for the pets because of the size of the fencing, tenancy hasn't complied with relevant bylaws related to the pet, pet's not suitable due to the number, propensity for causing damage. People might be able to disagree about some bits of it, but I think it's a non-exhaustive list for a reason, because it's one of these things lawmakers can't always envisage every different scenario that might possibly happen, because we don't have the wisdom of Solomon. We don't have the wisdom of Solomon, and the law needs to be general to allow for a range of different circumstances. So the aim of 42F is to outline some non-exhaustive examples of unreasonableness, but ultimately the test of that is through the tribunal, and that is just the status quo. That as I say, reasonable is in the Act I'm advised over 140 times. So ultimately the tribunal, there will be, I think this deals with Honourable Carmel Sepuloni's point as well, there will be tribunal cases as a result of the pet provisions, and that's entirely appropriate. My advice to landlords and to tenants is as it is for everything in tenancy law, which is things are always better when people don't go off to court. So no landlord wants to be stuck in the tribunal, and no tenant wants to end up in the tribunal complaining about their landlord and fighting through the tribunal. It's time consuming, it's expensive, it's mentally taxing, it's a nightmare for everybody. So no one wants that. So my general advice to everybody, and I say this all the time when I meet with landlords and when I meet with tenancy groups, which I do, is just be reasonable. Just act with compassion and common sense. Life would be a lot simpler if everybody just was reasonable. Now, I'm a reasonable guy, but clearly not everybody is reasonable. Otherwise life would be a lot simpler. So they aren't. And that's why we have the court system, and that's why we have the tribunal system. And if everyone followed the law, life would be good, but they don't. So we have things to make sure that rights and obligations are enforced. And so we have a tribunal. Will there be tribunal cases as a result of the pet laws? Of course there will, because it's not been legislated before in New Zealand, and it's new, and we'll just work our way through. That's fine. I'm comfortable with that. And, you know, if there's some really weird tribunal rulings coming out, well, as I said to the Honourable Kieran McAnulty, this will be an iterative process. We won't get everything right the first time. It's new to New Zealand law. It's the right thing to do. I think broadly people support that. We may have to come back and legislate in the future. That's okay. Parliament legislates all the time. It's all good. And we'll do that.
Sam Uffendale.
I move that debate on this question now close.
Carmel Cipollone, we will be looking for new material.
Thank you, Mr. Chair. Actually, a lot of the questions that I asked previously were responded to, except for one, and so I am going to re-ask it. Given that the Minister has said that there will be a longer lead-in time for introducing the PET provisions, is he going to go away and talk to the Ministry for Social Development about extending the housing product that will support lower income New Zealanders and beneficiaries to get access to additional bond to cover the expense for the PET bond, given that his own regulatory impact statement does state very clearly that it is low-income New Zealanders and beneficiaries that will be disproportionately and negatively impacted by a PET bond being introduced.
Kieran McAnulty.
Very much, Mr. Chair. I have a new question related to PET bonds. 18AA3. If the landlord lawfully increases the amount of the rent, the landlord may require payment of a further sum of PET bond not exceeding the amount by which the rent payable for 2 weeks has been increased. I know the Minister is trying to find a balance here, but we've established through various exchanges that for some people the level of PET bond may well be a barrier to them being able to have a pet, even if the landlord is willing to do so. And my question around this relates to what will potentially be an annual increase in the PET bond. Now, we already have in the material here that at 2 weeks, the average national weekly rent is $1,160. Now that's 2.9 times the median PET damage awarded by the Tenancy Tribunal in recent decisions, $402.50. The amount of damage isn't actually linked to the rent. And so if there's a provision where the PET bond is likely to increase on an annual basis alongside rent increases, that doesn't actually mean that the median PET damage is likely to increase at a similar rate every year. And so if the median PET damage is 402 and 2 weeks rent is pretty much 3 times that, with the potential for an annual increase. Now my concern, Mr. Speaker, is that for some tenants, they will rummage up the 2 weeks PET bond, but they may struggle to absorb the increase in rent. And now there's going to be an additional amount on top of that as the PET bond increases. I'm not disputing the rent increases. That's a discussion and argument for another time, possibly at another part of this bill. But in this one, I'm not sure that's necessary. And I can't see how this inclusion would act as an additional incentive to landlords when they've already got the bond, which is already 3 times the damage. If the rate of damages was going up at the similar rate, I could understand. But linking it to rent increases means that the discrepancy between the weekly rent, i.e., that's linked to the bond, 2 weeks rent for the bond, and the damage is just going to, over the time, steadily grow. And so if we look at the advice that was provided around the 3 weeks rent, and I'm pleased the government didn't go there, they did say they were trying to find a balance, it demonstrates that that would be too high and it wouldn't be effective. But over time, Mr. Chair, with this provision in here, we will get to that point. And we would end up in the situation that the government has been advised not to do. So I'm keen to hear from the Minister the rationale behind this. and whether he would be willing to consider adjusting this so that we don't have increasing deficiency between the two.
Mr. Chair, I'll just deal with that point because it's a good one. Firstly, in relation to Honourable Carmel Sepuloni's point, we've made a decision not to do that. So she's asking me to go away and talk to MSD. I've done that. And we're not doing that at this time. In relation to the Honourable Kieran McAnulty's point, so basically this replicates what is the existing law for general bonds. So if you are a landlord and you increase the rent lawfully, say $20 a week, technically you can require a bond payment, the bond that has already been lodged, because you'd be increasing it. You might be charging $500 a week, you might charge 4 weeks bonds, $2,000, and you increase the rent to $520. Technically, you can require an additional bond payment on top of that to reflect the maths around 4 weeks. I'm advised most landlords don't do that, and I don't know, there'll be plenty of tenants and former tenants in the house. Certainly, in my time renting and flatting, I never had the landlord increase the rent. But never had the landlord say, actually also you need to go chuck another $20 or $40 with tenancy services to reflect the 4 weeks. That just remains what was lodged at the time of the initial bond. So the provision in 18AA, it just replicates that provision for general tenancies without pets into the pet bonds. But I'm advised that most landlords don't do that, and my expectations would be the same thing would happen, but it just replicates what the existing law is.
Ryan Hamilton.
Debate on this question now closed.
Arana Williams.
To share for the opportunity to take a call on my amendment. This hasn't been discussed in the committee stage, and I appreciate the Minister's engagement on the issue of greyhounds. This is a new solution to the same problem, but an entirely different approach, Mr. Chair. The suggestion here is that because the Minister has really helpfully outlined for the House what the problem would be with the Honourable Kieran McAnulty's approach to add on essentially an ability for a landlord to claim back more costs if the damage was caused by a greyhound, thus eliminating the risk of discrimination by landlords against tenants for those who own greyhounds. The suggestion here is to prohibit discrimination against tenants who own greyhounds. This is something which is pretty common in the law. There are lots of things that landlords can't ask their tenant and can't be required for their tenant to explain to them, and also can't then make decisions about whether their tenancies can continue based on those factors. This would add in, my amendment as it is drafted now, would add in a prohibited grounds of discrimination if someone owns a greyhound. That's a good point from the Minister, that we don't want to accidentally cause a situation in the law where it's cheaper and therefore easier for a landlord to limit their risk to pet damage by making sure that if there is going to be a dog in the property, it's not going to be a greyhound. This would simply not allow them to ask the breed of the dog, and it would mean that it was a prohibited grounds if they did know that the dog was a greyhound. Some simple changes there, which the House is probably ready to take a policy position on, because it's quite simple, and it would amend the law in a way which also doesn't require any further work to be done to bond 2000. As the Minister said, one of the concerns he had with the Honourable Kieran McAnulty's amendment is that there is some work to do by MB here to get the system up to speed. But because this amendment is drafted in a way that means the landlord may not require the payment, there is no need for the payment to be made in the first place, and therefore there's no requirement for the payment to be paid back. So it doesn't hit the system at all. So if we do it this way with a prohibited grounds of discrimination, no money's changing hands, and there's no system requirement to push it out.
Tom Rutherford.
I move that debate on this question now closed.
The question is that debate on this question now closed. All those in favour say aye. To the contrary, no. The noes have it. A party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakahe.
Act New Zealand.
11 in favour.
New Zealand first.
8 votes in favour.
Te Pāti Māori.
6 opposed.
The ayes are 68, the noes are 55. The question is agreed. The question is that Honourable Kieran McAnulty's tabled amendment inserting new subsection 1B to his tabled amendment to clause 8 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand
8
first.
votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Honourable Kieran McAnulty's table amendment to clause 8 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand
8
first.
votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Arana Williams' tabled amendment to clause 8 inserting new subsections 1A to 1AC be agreed to. All those in favour say aye. To the contrary, no. No. The noes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand first.
8 votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Steve Abel's amendments to Part 1 set out on AP number 218 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand
8
first.
votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Ricardo Menendez March's amendments to Part 1 set out on AP number 219 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 opposed.
New Zealand first.
8 votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Tamitha Paul's amendments to clause 16 set out on AP number 220 be agreed to. Those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
Act, New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Timothy Paul's amendments to clause 16 set out on AP number 224 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote is called for. Please conduct the party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
Act, New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Timothy Paul's amendments to clause 16 set out on AP number 225 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote is called for. Please conduct the party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
Act, New Zealand.
11 opposed.
New Zealand
8 votes
First.
opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that Francisco Hernandez's tabled amendment to clause 16, new section 42E1, replacing 21 days with 14 days, be agreed to. All those in favour say aye. To the contrary, no. No. The noes have it. Party vote is called for. Please conduct the party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
Act, New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
6 in favour.
The ayes are 55, the noes are 68. The question is not agreed. The question is that part 1 stand part. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote is called for. Please conduct the party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakahe.
Act, New Zealand.
11 in favour.
New Zealand
8
First.
votes in favour.
Te Pāti Māori.
6 opposed.
The ayes are 68, the noes are 55. The question is agreed. Members, we come now to part 2. This is a debate on clauses 21 to 29, termination of tenancies. The question is that part 2 stand part.
Mr Chair.
Arana Williams.
Thank you, Mr Chair. I have 2 questions for the Minister to start this section off. This is the part of the bill where the rubber hits the road for tenants, where their rights are being stripped away by a government that does not care, that it is weakening their position, where it is making landlords empowered to not only kick their landlords out with 90 days for no reason, but also to weaken their rights in other ways. And we've spent a whole part discussing how the government is being so kind with its approach to pet bonds without any sort of analysis about how the market will be affected. Not only will rents continue to rise under this approach, as the Treasury predicted at its budget predictions, but also people will be affected here. There is no intention, as the government minister and the chair previously said, for MSD clients and those receiving a benefit to be able to use the benefits to increase their availability of PEP bonds. There's no intention here for further work to be done on that. So my question to the Minister is, if we're weakening the rights of tenants here by increasing the incentives for investors to buy up more of the existing stock of properties, that's the effect, and at the same time we're making insecure tenants feel like even more desperate that they need to get into a house of their own, both of those factors will push rents up and up. And so is it his position that clause 22, which reintroduces 90-day no-clause evictions, will drive up rents? And does he agree with Treasury's predictions at the last budget that rents will continue to rise under his watch?
Tangata Paul. Sorry.
And kia ora, Minister Pōtaka. Nice to have you here, and hope that you'll be able to respond to some of my concerns that I'm about to bring up. So I believe this is the appropriate part to bring up what I was trying to get at previously, but I want to dig into the evidential basis behind no-cause evictions, because, Minister, you're making a really big call in bringing these back, given that this is going to impact more than 1 million renters in our country and make them vulnerable to being evicted and kicked out of their home for no good reason. And so I want to understand where's the evidence, because we were told throughout the Select Committee that the rationale behind this bill was that it would allow landlords and property managers to take a chance on risky tenants by bringing them in and being able to kick them out if they don't like their behaviour. But where's the evidence for that? I mean, that didn't come up at all throughout the Select Committee process in my recollection of it. So I'm just trying to understand where the facts are to back that up, because I don't think they exist. And I believe that the reason that these no-cause evictions were brought back was because it's politically popular to do so, despite the fact that in the submissions on the bill around no-cause evictions, again, 97% of submitters were opposed to no-cause evictions being brought back, and 53% of property managers and landlords were also opposed to no-cause evictions being brought back. So where's the facts to back up bringing them back, given there's such huge risk to the 1 million plus New Zealanders who are now vulnerable to being kicked out for no good reason at all?
Honourable Carmel Cipollone.
Mr Chair, I sat through the submissions, and this was the most contested part of the bill. So many issues were raised with the additional vulnerability that will be put on tenants as a result of reinstating the no-cause termination for tenants, Mr Chair. And we were all concerned, sitting in that Select Committee, concerned that we're going to see more transient families, concerned that we are going to see families discriminated against, and they will not take up their right to that retaliation clause that's in here, because that is incredibly complex. And as we know, many of these vulnerable families are not likely to go to the Tenancy Tribunal to complain about their landlord. Mr Chair, there are a number of things that I'm concerned about when I look at even the disclosure statement for the bill and also the regulatory impact statement. I want to know from the Minister why he has decided to ignore the advice in the regulatory impact statement where it states landlord's ability to terminate a periodic tenancy in any other case, a no-cause termination, was considered to negatively impact tenant well-being and disincentivise them from exercising rights and raising concerns. That's what I was just speaking to, and it's actually in the advice that accompanies the bill. The statement also noted that although the RTA enables tenants to challenge terminations they suspect have been issued in response to them exercising their rights, tenants may not feel empowered to do so, as it may be difficult to prove this if no reason is provided. Mr. Speaker, I need to question the Minister on how he would allow this to go through, why he will not consider any changes, given the fact that the submissions were overwhelmingly opposed to this, and even the officials' advice state or reiterate the same concerns that were raised by, I do believe, as Timothy said, 97% of submitters, Mr. Speaker. Mr. Speaker, during the Select Committee process, Mr. Chair, I raised a question that was unable to be answered by the officials. However, I wanted them to go away and see if they could find the answer, and I'll put that question now to the Minister. And that question is in relation to how long it actually takes an individual or a family to find and secure another rental property once they leave, have their tenancy terminated, the property that they are residing in. Because I'm concerned, Mr. Chair, that we were never presented with any evidence to show that in cities, in areas where there are housing shortages, places like, I can say, West Auckland, where it's quite often difficult to secure a rental, that 90 days may not even be sufficient for that family or individual to be able to secure their next rental property. Mr. Chair, as an electorate MP, we have seen this over the years, particularly, I have to say, between 2008 and 2017, where we had a number of constituents who would come through our office very clearly stating that they were not able to get into another rental property, and so therefore were in a position where they were seeking out emergency accommodation because of the fact that rental properties were not widely available or easy for them to access. So I want to know from the Minister whether or not he received any advice on the risk of those who have their tenancies being terminated and not able to find their next rental property, having to seek out support from MSD for emergency accommodation, and what that might mean for the Minister's own target of reducing emergency housing in this country.
Honourable Kieran McAnulty.
Very much, Mr. Chair. It's pretty disappointing, to say the least, that the Minister hasn't taken the opportunity to stand up and respond to what are genuine and frankly straightforward questions. Because if we are actually to be able to dive into this part, the substance of the bill essentially, we need to understand the government's rationale. We need to understand what they have based that on before we can actually look in great detail about why they've landed, where they've landed, the number of days, etc. Because we know that when this bill was announced and as it has progressed through the parliamentary system, the government have claimed that this bill will help address the housing crisis. Now, up in the first part, we have discussed this, I think, quite constructively. We've come with ideas on how to improve it, but we can't even start to look to improve this until we understand what it's based on. Now, previously, if a minister isn't getting up to answer questions, we can rely on the regulatory impact statement to give us an idea. But it's quite clear when this is read that the government didn't give departments enough time to actually come up with analysis to assist Parliament. Now, that's not the department's fault. It's another example of the government cutting corners to try to avoid scrutiny, which makes it even more important that the minister stands up and answers questions. But if we dive into the regulatory impact statement enough, we will see that the government's claims that this bill will help the housing crisis appear to be unfounded. I say appear because it hasn't been able to reach that conclusion because they weren't given enough time. And the only way that we can get to that conclusion, or otherwise, is if the Minister answers questions. So I'll bring it right back to the most basic point. In the absence of a response, once the Minister does respond, we will certainly have more questions, but I'll keep it real simple. How does this bill help solve the housing crisis? There's no mention in this bill about building houses. And actually, we've got to look at this bill and this part in the context of the other changes that this government has made. Because the Minister needs to answer that pretty simple question in the context of them reversing the changes the previous government made around interest deductibility, in the context that, at least in part, but I would argue predominantly because of that change, rents have gone up 7%, according to the regulatory impact statement, in the year leading up to this. What is going on here? We need to know from the Minister how this is going to solve the housing crisis.
Mr. Chair.
The Honourable Tama Potaka.
Thank you for the opportunity to stand and respond to some of the questions today. I was really unfortunate I was unable to sit in the chair in relation to the pet bonds, because that's quite an issue dear to my heart here in the fishbowl of Wellington. The changes that have been proposed in this part of the Act are sensible, much needed, and remove some of the barriers to ensure supply and flexibility for landlords in the market. Of course, there's been some observations, nay I say allegations, around rent increasing as a result of some of these changes. But as we know, rents have dramatically increased over the last 5 or 6 years, and over the last 12 months there's been some stabilising of rent. But rents do get influenced by a number of matters. For example, immigration, supply, wage growth, and it's clear to us that an increase of an average of $170 over the 6 years prior to the 2023 election, despite an extraordinary amount of coin being tipped into the housing market by way of subsidies and build costs, despite that, rents continue to increase. Despite some of the current arrangements around terminations being put in place, rents continue to increase at a pace that has actually contributed significantly to the cost of living catastrophe that has faced ordinary New Zealanders, including those ones in West Auckland. The view that changes is that changes will increase supply, and whilst that might come as a surprise to our colleagues on the other side of the whare, it is our view that the changes that are being proposed in the context that they're being proposed and together will increase supply at the margins by giving landlords greater flexibility to rent to tenants and to a broader suite of tenants. And that's something that I've obviously witnessed, been involved in the property sector myself for the last 2 decades, and the sense that and the view that our team has on this side of the House is that by making these changes, we're able to see a lot more landlords be interested in broadening the suite of tenants and people who may rent homes, rented tenancies from those landlords, because there's an increasing flexibility to deal with some complexities which currently cannot be dealt with under the current legislation. You actually get more choice for access by tenants. And whilst there have been some observations around 52.8% of property associations and landlords opposing the change, actually within some of those associations and groups who presented or who submitted during the select committee process, there are a number who submitted on behalf of many, many other landlords. So yes, acknowledge this, the submitters and the percentage of submitters, but when you actually get to the percentage of landlords opposing or not opposing, we don't and we haven't been able to penetrate that number. And whilst there are some observations around the reletting and the impact on the tightness of the market, recent evidence suggests that actually the time taken to relet properties is actually longer, suggesting that the changes and the approaches that we have made actually showing that the tightness in the market is easing. So again, we believe that there is a sensible, much needed change, and that's captured here in this part of the Act. We do believe that it will increase flexibility for landlords, but also generate a greater opportunity for tenants to access rental arrangements. Very sensible, and I commend Minister Bishop for his hard work on this matter.
I'll just make the note that, of course, the Minister, by covering quite a broad range of issues there, has actually opened the debate considerably, and that will be, no doubt, taken into account in considering the subject matter of questions. The Honourable Carmel Sepuloni.
Mr Chair, I do want to continue on. The Minister started by stating that he wishes he'd been here for the previous part of the bill with respect to pet bonds, because pet bonds are close to his heart. I want to know whether or not Treaty of Waitangi obligations and Māori are close to that Minister's heart, given what is in the regulatory impact statement for this bill. Mr Chair, it's important to note that in this bill it states evidence suggests that the termination-related proposals will negatively impact on actual and perceived security of tenure for many tenants compared to the status quo. These negative impacts are likely to disproportionately affect Māori, as Māori are more likely to live in rented accommodation, have a lower overall median income, and are more likely to experience discrimination than the general population. So it's lovely that that Minister cares so much about pet bonds and that those are close to his heart, but this part of the bill is about the termination clause that he's bringing back in, so that there will be no cause for termination and people can be booted out of their homes with no reason whatsoever. His own advice is telling that Minister that Māori are going to be disproportionately impacted. Now, I want to know if Māori are close to that Minister's heart, and how he can justify this particular change, given that the evidence is right in front of him to say that actually they will be negatively affected. We heard that the spin from the Minister that this will result in more properties being tenanted, in a broader suite of tenants getting access to rental properties. I don't know what broader suite of tenants means, but I do want to assume that he means Māori getting access to rental properties as well. However, if he is inferring that, then it's interesting to see that the evidence he was giving contradicts what he said when he took his feet. So, Minister, I want to hear from you that Māori are close to your heart and to understand why you think this particular provision is going to be a benefit to Māori when what we have in front of us in the regulatory impact statement says the exact otherwise.
Celia Wade-Brown.
Thank you, Chair. And I've got a number of questions to the Minister about Part 2, Clause 22, which seems to return the imbalance of power between tenants and landlords. The benefit to landlords is clear, But what does the Minister think is a benefit to tenants? Does he think that tenants will really be empowered to raise the retaliatory power? Do you think that they will be able to take that up? When I'm a car owner and I am a landlord, to check that my car is safe and healthy, it's not me that says my seatbelts are fine and my brakes are fine. I take it to the garage to have that checked. Healthy homes, I just make a declaration that the house, which I firmly believe is a healthy home, but there's no inspection unless there's a complaint. That's not fair. If a tenant wants their home to be healthy, not cold, not with non-compliant fires, poor heating, non-compliant smoke alarms, they are not in a position of power to raise those things. And let's look at what this removal of this return to the no-cause evictions does for tenants' health. Their physical health, I've alluded to with the healthy home aspect, but the mental health, the insecurity, the chances that they will have to move not just within their suburb where their child goes to school or they're on the doctor's list if they're lucky, but they might have to move somewhere else. And the worry about it, even if they don't, the worry about it is completely unreasonable. I have a little bit of insight into this issue, both as a landlord who's happy to have a healthy home, but also I grew up in a council flat in London. At the age of 18 months, which I do not remember, we actually did have to move because the house was demolished for widening a road, which may have formed some transport views, I admit. But then my grandmother, my half-sister, my parents and I were rehoused in another home. And we never worried about whether next Christmas would be somewhere else, whether I'd be able to go to the same preschool or the same school. We were able to be in the same place. What does the Minister think that this change will do for school attendance rates, which are very important? We agree across the House, but making families move. So would they consider an exception for families with school-aged children? Would they consider, and I'm surprised New Zealand First perhaps hasn't brought this up, an exemption for 65 plus? My other half-sister, I have a few, lives in Austria. She lives in a private rental. She's lived there for years. She's got gardens, she's got chickens. I don't know whether they count as pets. She's got a cat and a dog. And she feels safe there as long as she wants to continue living there. She's been there for 8 or 10 years, whereas most people's tenancies in this country are far shorter. She knows that she can invest in furniture, curtains, the garden, the fencing, without fear of being moved on in 3 months. And in fact, we are completely out of sync with many countries in our rules about tenancies. I'd like the Minister to respond as to whether he thinks Sweden, Belgium, Denmark, Switzerland, Spain are mistaken in not having no-cause evictions. There's got to be a serious reason. In Spain, for example, if the landlord wants to sell the house, first of all, the tenant has a first right of refusal, I think. But secondly, if the house is sold, or the flat, the tenant can remain through that process and be a tenant of the new owner. We are very, very unreasonable, unfair, and uncompassionate towards people who rent. And that results in them being regarded as second-class citizens, whereas other countries, it's perfectly fine to rent all your life, to expect that your children will carry on renting in the same place.
Mr. Chair.
The Honourable Jenny Anderson. I'd like to just get some more information from the Minister, because he made some interesting statements and we still haven't quite managed to get to the point of what the policy problem is in relation to reintroducing those 90-day terminations. And so he did state that, I think the term he used was a wider suite or a broader suite of tenants would be available, like it's like a box of chocolates or something. I didn't quite understand that. So when we go back to the regulatory impact statement, what it says in there is that the National Party's manifesto documents and the ACT Party and ACT Coalition Agreement committed to reversing some of the changes made in 2020 to the Residential Tenancies Act. So my question to the Minister is, maybe that's the primary underlying purpose. Maybe he would like to speak to that, because the regulatory impact statement does say that there is no clear evidence that the changes in 2020 actually caused an increase of rental supply or rent prices going up. It states in there that a wide range of complex factors influence rental supply and rent prices, and assessing the impact of individual factors is not possible. So it's not able to be stated that that's in fact the case. And so his own regulatory impact statement in fact states that landlords, property managers and investors and organisations representing these stakeholders made a big plea to the government and wanted those 90-day no termination notice given to be able to be reinstated. So from the regulatory impact statement, it does appear that there is no factual cause or causal link between increased rent prices and that it's a clause or a part of a political agreement that underpins how this government got power, and that they were quite strongly lobbied by those landlords and those who stand to gain from kicking out people with no notification there. And so that is a real concern, because I think what it does is that the Minister needs to provide some evidence regarding the impact of the 2020 tenancy law reforms on rental supply and rent increases to demonstrate why this has been lifted. Because as we've already seen from recent evidence provided from Statistics New Zealand, is that rent prices have continued to be high for tenants. In fact, their inflation rates are going up higher at a higher rate than CPI, given what the government's already done to taking away the interest deductibility from landlords. So if they've already given landlords a tax cut and that's made no real impact upon rents coming down, they're going up more than food, then how is this additional provision? Because it looks like he's just helping out his mates by giving tenants a rough deal. And what is really concerning to me, Mr. Chair, is that does the Minister think by giving tenants a puppy that they're going to ignore the fact that they can get kicked out of their house with no real cause? And that's the kind of sickening part about this bill when you put part one and part two together. Does the Minister think that giving people a puppy or a kitten compensates for the fact you're taking away their rights to live in a home? And your own regulatory impact statement talks about the direct impacts upon tenants in terms of family violence risks, mental health risks, children attending schools, all of those crucial factors that already impact upon people receiving lower wages. If they are kicked out of their home without any real reason, because landlords can, what are the social impacts on those people and how they continue to provide for their families and have stability in their lives? Because it seems to me that the own regulatory impact statement provided by the Minister indicates that there are some significant risks. So I think it is incumbent upon the Minister to explain the actual policy problem that is trying to be fixed with this legislation that does appear just to be serving his mates.
Mr. Chair. Ricardo Mendes March.
So, noting that the previous chair had talked about broadening the scope of the debate as a result of the Minister and how part 2 touches on particularly the impacts of no-cause evictions on people. I wanted to take it, first of all, to the Growing Up in New Zealand study, who identified that young people who had to move from their homes for reasons outside of their control, such as tenancy terminations, were more likely to experience homelessness and lived in greater levels of hardship. My first question was, how can the minister say this to help landlords take a chance on people who might otherwise be homeless, when the flip side of that is that no-cause evictions and weaker security of tenure also lead to more people becoming homeless? The second question I have in relationship to this is, what difference does it make if you're hoping that this government policy will reduce homelessness on one side and then the policy causes homelessness on the other? My third question was in relationship to the language that has been used by the minister and other government ministers about landlords taking a chance on people. I wanted to understand if the minister had a more granular definition on the types of groups that he believes landlords will be taking a chance on, because I have heard language like risky tenants, for example, from some government ministers, and I want to understand what does that mean to the minister actually, because I actually think there is a bit of marginalization happening when it comes to the language that is used in relationship to the types of tenants that, particularly in part 2, we're talking about when it comes to, you know, the argument that landlords will take a chance on specific people. Like, what does he mean by that? Because to me, I can imagine some of the types of people that he may imagine, but I don't think those people deserve to be labeled as risky. I also had a question, so my fourth question, and I'll recap all of those, related to particularly some of the outside influences that he has alluded to in relationship to the need for particularly the provisions in Part 2 of the bill. I am really curious to understand what evidential basis he's drawing upon to justify immigration settings to speak to the need for these provisions in Part 2. I'm particularly interested because he's made those comments in this debate. I think those comments should be based on evidence, and I just simply don't think that it's helpful for a minister to be whipping up immigration settings to justify no-cause evictions, when actually, like, no-cause evictions will affect migrants, no-cause evictions will affect other members of the communities, and if the minister wants to summon immigration settings to justify this bill, I think we deserve an evidential basis for that. What we do not deserve are ministers whipping up anti-immigration sentiment to justify this bill, when actually the reality is that this isn't even a government that is committed to building enough public housing. Anyway, to recap my questions, I wanted to understand whether he used the Growing Up in New Zealand study at all when it came to making decisions on this bill. How did the research that's available to the minister play a role into this? And then the second part is around the evidential basis for his arguments that this may reduce homelessness versus, for example, the risk of increasing homelessness. I wanted to get a clarification, a more granular definition of the types of tenants he perceives to be the ones that landlords will take a, quote, risk by taking them on. And then finally, the evidential basis for how immigration settings justify this bill.
Mr. Chair. Honourable Carmel Cipollone.
Thank you very much, Mr. Chair. Some of mine, I think, really carries on from Ricardo Mendes, but also some of the earlier questions that I asked. I do want to clarify that earlier I was speaking about the impacts on Māori. I think I might have said it was in the regulatory impact statement, but it was actually in the disclosure statement. So just to make that clear. Now I am looking at the regulatory impact statement and very interested to see that this policy of reintroducing 90-day no-cause terminations has been assessed for effectiveness and efficiency. And for effectiveness in terms of landlords and giving them what they've asked for, and the reassurance that they'll be able to regain control of their property whenever they want, well, that's double plus, so highly effective. In terms of supply, though, which I think is important to mention given that the Minister earlier said that this will lead to better supply of rental property, it's zero. This actual policy will not necessarily lead to more houses or more rental supply on the market. What I am particularly concerned about is efficiency, where it states that as a result of the reintroduction of 90-day no-cause terminations, there may be more churn in the market and higher residential mobility among renters. Higher residential mobility is associated with lower education, employment, health and well-being outcomes. Mr. Chair, I want to ask the Minister what impact this policy, with that in mind, is going to have on their government priority targets in various other areas, including their education targets and their target to reduce the number of people on job seeker benefits. It's really clear that the advice is stating that this could lead to more transients, more housing mobility, and that there are social repercussions for that. So from the Minister, what is the advice that he's received on their government targets and their ability to reach those targets as a direct result of this policy being implemented?
Tamitha Paul.
Thank you, Mr. Chair. I'm grateful to take a call on this, particularly following the previous speaker's guidance around the Minister's answers kind of opening up the broadness of what we can cover in our questions. But I will stick to no cause evictions because obviously that is the part that we're on. And I noticed that there's been a number of calls now, 3 or 4 of them, and the Minister hasn't stood up and answered any of those questions. So we still don't know what the evidential basis of this bill, and particularly behind no cause evictions, is. And that's basically leads me to all of my questions, because there's so much in the RIS and in all of the supporting information around this bill that points to the fact that there is no evidential basis for the bill. But the problem is that when you don't answer, when he doesn't answer the question and doesn't clarify what we're all trying to understand, which is what led this government to make the decision to bring back no cause evictions, it just leaves a whole bunch of space for speculation. And that's why all of us are all asking the same questions, trying to determine what was the driver of this bill, what was the reason, because there isn't a reason. Because if you look even at the RIS, it talks about the fact that this was something that was agreed to in the coalition agreement. So you can see that there's a bit of a track record going on here where we're having decisions made for us, and decisions made that impact a lot of people in this House, and simply on the basis of a coalition agreement. That's not a responsible way to make legislation or policy. And then to have the Minister stand up and say, in response to the lack of evidence behind it, that, making all of these claims, if you actually look at the RIS and what those statements that you were making, they do not match up at all. So how are we supposed to do anything except speculate on the intentions of this bill when we're not getting any answers? And there's a big vacuum that's been left. But we can move on from that one, because the question that I want to understand is, like Ginny said, and didn't get an answer to, what is the policy basis? What is the problem that we're trying to solve for this bill? That question's already been asked, but my follow-up to that is, did the government explore other potential ways to achieve that outcome that you seek? Because if the so-called intentions of no cause evictions is to make it easier for landlords to take on riskier tenants, whoever that is supposed to be, then surely there are other ways to achieve that outcome that actually are founded in evidence. But clearly no alternatives have been explored in developing a solution to that policy problem, because the outcome was already predetermined in the first place. They already knew exactly what they wanted to do because, again, it's in this magical coalition agreement that seems to overtake literally everything, including the founding document of our country, but I won't go there.
You should.
Yeah, I might, because we've opened up the can of worms, haven't we? Yeah, the can of worms is open. We've got Hanarapati over here. No, I'm just kidding. Okay, all right, back to this. So there was one point in particular that I wanted to touch on in the RIS, and it's paragraph 106. Oh, and it just so happens to be the Treaty of Waitangi analysis of the termination proposals. That's great, that's convenient. Okay, paragraph 106, to quote, as a result, the proposals may increase the risk that more households will need emergency housing and or social housing. So, again, that makes me scratch my head about why are we pursuing this policy that is going to have major implications for the amount of people having to access emergency housing and public housing. Because we're talking about these riskier tenants, and I'm sorry, but it's hard to not jump to the conclusion of who you're talking about when you're talking about these riskier tenants, and also those are likely to be the people that do need to access emergency housing and social housing. So have we thought about those implications in terms of bringing back no-cause evictions? And the other thing, my colleague Celia Wade-Brown made a number of questions and talked about her experience within housing, and I think she raised some really important points that, again, were not responded to, about the way that different countries have chosen not to adopt no-cause evictions. But the particular example that I want to bring up that she didn't touch on was no-fault evictions. Mr. Chair.
Tamatha Paul. The Honourable Tama Paul-Tucker.
Cool.
Mr. Chair, thank you for the time to stand and to respond to some of the opinions that have been surfaced. And again, I hark back to one of the whakatoki, or the proverbs of my father. You are entitled to your own opinions, but perhaps not your own facts. And the government's proposals are intended to support supply and continue to keep downward pressure on rents. And whilst the opinions of various members opposite are very strongly and genuinely held, might I add, the opinion of the government is that at the margins, the changes that are proposed will support supply. And there has been a comment, and quite a podium comment at the Hyperbole Olympics around immigration being a driver of my observations. In fact, I've had very, very little comments, and I think that myopic nature of that particular comment is merely to fill out the Hansard. Please do not put words in my mouth when I didn't talk about immigration being a cause of my observations and the policy basis. Right, I did mention it. However, I did not mention it in substance, and starting to leverage that concern around immigration up and putting words in my mouth is highly unbecoming of that member. There was also a number of comments around Māori and Te Tiriti o Waitangi. Guess what, people? Māori are disproportionately renters in this country, but also Māori are landlords. And those Māori landlords would welcome the flexibility to offer tenancies and houses to renters, whether they are Māori or not Māori. And whilst the members have opined and pontificated about what broadening choices for Māori renters means, I'll make sure to get those tamariki Māori out of emergency housing, which the members opposite can sign many tamariki Māori to, living in dank emergency hotels and motels throughout the country. Fact, price inflation for new rentals has actually gone down from 7% as at the end of the previous government's administration to 0.7% in the last couple of months. That again is an absolute illustration of the contextual changes and signals that this government is undertaking. And again, the provisions in this part of the bill are all about resetting the housing system as a whole and ensuring that we actually do provide for those many thousands of people who actually need a house, and particularly those at an affordable level and an affordable rental. Again, there's a whole range of comments that have been made by members opposite about risks. But as the previous Minister for Social Development knows very well, the actual social allocation system is based on risk and need. So again, those members opposite who have commented around risk should take some time to undertake the relevant research required to better understand the housing system.
Ricardo Mendes March.
Thank you, Mr. Chair. Well, it's been quite interesting hearing the comments from the Minister accusing us of having a bunch of opinions when actually he's responded with zero substance on the matter. And I think that does a disservice to the process here, which is to actually scrutinise the government and actually the Minister's own understanding of his own legislation. So I may just test the Minister on a more technical matter, particularly in Clause 22 and the changes to termination by notice, particularly in the provisions that allow for less than 90 days to be given. So if we go to subclause 2, around a landlord may terminate a periodic tenancy by giving at least 42 days notice. There is a part there where it talks about whether the owner, that it includes the owner of the premises requires the premises within 90 days after the termination day as a principal place of residence for at least 90 days for the owner or a member of the owner's family. And I want to understand the Minister's technical understanding of this part of the bill around what recourse exists for tenants who get basically kicked out of their the place that they live, the home that they live in, if the landlord tells them that they need it for a family member, and then turns out that family member never moved in, or so the family member moved in for just a week. Because I think this part of this bill, this provision, makes it so easy for landlords to give way less than 90 days notice. It makes it so easy for a landlord to basically just say, well, it turns out I've got a sibling coming over, turns out I've got my son's coming over to stay for the holidays. And if those plans never eventuate, you could end up easily kicking out a tenant with that home remaining vacant, and the tenant may find themselves with no recourse. And if there is recourse, I'm keen to know what it is, and how easily does the Minister think it can be accessed, and whether the Minister thinks it's fair for the provisions of this bill to allow, for example, for a tenant to be kicked out under Clause 22 for, say, a family member to stay in that property for 1 week, when actually for the tenant that's been kicked out, there's a whole life being turned upside down, potentially, as my colleague Tamitha Paul noted in the regulatory impact statement, which I'm surprised that the Minister is dismissing as just kind of opinions and ways to fill their hands are, as potentially increasing the need for emergency housing. So I go back to the fact that it seems to me there are provisions in this bill that have enabled landlords with very few protections for tenants to tell someone that they've got a family member staying over for a week. And that is not good enough. We should not be allowing landlords to actually kick someone out, to turn someone's life completely upside down, to potentially push them into emergency housing because a family member wants to stay there for a week. Potentially provisions that may not need to even be substantiated by the landlord. And so I want to understand what's the Minister's understanding of the recourse that exists for tenants to address this if they find out that actually that family member never moved in, or if the family member moved in for, say, a very, very short period of time. And whether, if that recourse exists, whether he thinks it's realistic.
Mr. Chair.
Honourable Karen McNulty.
Mr. Chair, there's a reason we keep asking the Minister for evidence, is because he has refused to provide any. And it's very difficult to then dive into the detail of this part without understanding what the government has based their policy position on. Because we cannot rely on the regulatory impact statement, because as I said earlier, the government didn't give the department enough time to provide that detail. And if we are to understand why the government landed on 90-day notice, on 90 days, and why in certain circumstances they landed on 42, as is outlined in Section 22, Part 2, we need to understand what it is that they're basing it on. And the problem for the Minister in refusing to answer a pretty simple question is that it becomes very clear that it's not based on any evidence. The other issue that the Minister has in trying to stand up and be clever, he's broadening the debate every time he stands up. And this was something that was noted by the previous presiding officer. So instead of just answering the question, like in fairness, the previous minister did, if you look at the way that Minister Bishop deals with this, he stands up and says, now the question from this member, here's the answer. The question from this member, here's the answer. What do we get from this minister? Bluster and arrogance. But he has introduced state housing. He has introduced emergency housing, which is very interesting because the government claims that by, as outlined here in this part, by bringing it to 90 and in certain circumstances 42 days, this will help solve the housing crisis because it will mean that more landlords enter the market. I presume that's the case. They haven't actually made that connection. They haven't based it on any evidence. It's at the moment, it's just their reckons. Now, Minister, you are a landlord. Can you honestly tell the House that these changes are going to help your tenants? I don't think any landlord can. But it does help landlords. Now, if this was part of a broader policy program, perhaps they might have a point. But since the Minister mentioned social housing, let's look at the broader context in which we need to look at this bill. This government has sent a letter of expectations to Aotearoa which says that houses built next year will be 50% of the number of houses built the previous year. The houses after that will be only 400, and in Auckland, that number will reduce by 200. So Aotearoa isn't going to be building houses in the future. If we look at the community housing sector, this government has funded only $750 a year over the next 2 years. Additionally, during scrutiny week, it was clearly established when talking to MHUD that this government's policy of tightening criteria in emergency housing is meaning fewer people are getting in. They've accepted that the need has not reduced, but acceptance rates have. Now, the way the government is spinning that is that they're reducing the numbers in emergency housing. What's actually happening is they're not letting people in.
Yep.
Why is that important? One, the minister's made it relevant by his responses, but two, it is in that context that we ask the government, how is this going to help the housing crisis? If they are not building Aotearoa houses in the future, if they are not funding community houses to the extent that they have been funded and to the extent that is needed, and fewer people are getting into emergency housing, this, by the minister's own suggestion, will lead to more landlords entering the market. The level of consents have fallen through the floor. 12,000 construction workers have been laid off since this government came in. Where are these people going to go? This here means that fewer first home buyers will be entering the market if, by the minister's own logic, reducing it to 90 days and in certain circumstances 42 days, more landlords will be going for existing stock. How does that solve the housing crisis? Two very simple questions which the House deserves a direct answer to. What evidence is this based on, and how will this help?
Anna Williams.
Thank you, Mr. Chair. And I thank the Minister for engaging on this point about the effect of this change, specifically to 90-day no-clause evictions, to the availability of rental properties and to the price of rents. It's helpful to have the Minister's analysis on the record, although I don't think we've gotten to the bottom of whether this helps or hinders. And even if we take his sort of framing of what this is meant to do as just around the margins, it's not something which will fundamentally change the supply and demand for housing in New Zealand's market. I want to test with him some of what he's told the House about the evidence that he has to refute Treasury's position that rents will continue to increase in this forecast term, because he has refuted that, but not why. So I'm going to put to him what I think he's said in a way that we would also agree with, and then test it out from there. I think what he's said is, to use his words, resetting the housing system as a whole, and this is part of that. And I think what we're debating here is how to achieve better outcomes for both first home buyers and renters. And I would posit that requires ministers to move away from the zero-sum cycle of speculative investment which has characterised the New Zealand housing market in the last 2 decades. So my question for the minister is, in the situation where we have a limited supply of housing, where this measure does not increase the supply of housing, but it does incentivise, by weakening renters' rights, it does both incentivise landlords to buy up the existing stock, and it incentivises first home buyers to buy, because it is now harder to be a long-term renter. If not at the sort of 25 to 35 stage, but if you're a 35-year-old to 45-year-old that might have the capital but might be choosing to rent anyway with young children, it now becomes even more important that you are not subject to the vagaries of your landlord's whims, where you might be required to move within 90 days for no reasons. It's even more of a desperate situation to get into your own house. And so both of those things are being driven up under this law change. So my question to the minister is, even if we accept that this is just about addressing housing supply at the margins and demand issues at the margins, doesn't this create a situation which is worse for the housing market, that we incentivise the prices of houses to go up and up, even if it is just at the margins? And my question really to him is about whether this change is something that could not have been designed in a way where it only was about new stock, or because he has given us a good sense of, well, this is about a number of other suite of changes which reset the housing system. So was there not a way that this campaign promise of various coalition partners could have been introduced to only affect new housing stock? Because the minister, in his answer to my questions, said that there was a need for more houses to be built. That is right. That's not what this does. There's no incentive here for investors in houses, for people who can afford to be landlords, to buy new houses or to build new houses themselves and then rent them out. This actually incentivises them to buy older houses and to sort of play in a market of renters who were on the margins. By his own admission, if this is about offering risky renters more housing options, then we're down at the bottom of the market there rather than the top of the market, creating more additionality of housing supply. So can the minister help us understand, when he says that this is around the margins, what actual effect is this going to have on rents? And can he clarify over the House whether he disputes the predictions that rents will continue to rise in the Stats New Zealand's figures? Because though he's given us the figures which support his claim for downward pressure on rents, we dispute that, given the official statistics show that there is not a change overall in the market. There are some regions where that does seem to be the case, I'll give him that. South Auckland is one where migration is having such an effect that rental properties seem to be coming down in price or are hard to rent at the moment. But overall, the Statistics New Zealand data, that is the latest set of data, shows that rents continue to rise as Treasury predicted.
Mr. Chair.
Francisco Hernandez.
Comrade Chair, for allowing me to take this. Mr. Chair, for allowing you to take this call. I just have a question to the Minister, a few questions. My first question is...
I'll go with Mr. Chair.
Mr. Chair. Mr. Chair. That's why I clarified and said Mr. Chair. Mr. Chair.
You name it.
Yeah. My question to the Minister is, can you... I appreciate your reply on the question of immigration, so I just want to invite you, in your own words, to explain why you even mentioned it in the first place in response to some of the earlier questioning. If your intention was, as you say, and I'll take it on good faith, that you didn't intend to, kind of link the issue of immigration to, the issue of housing, the housing shortage at all. I think we appreciate, I guess, in light of international events and how there's been, a rise in xenophobia and anti-immigration politics overseas, why we might be sensitive to it here. I also want to ask questions about turning to Section 22 around the question of termination of notice. We know that the RIS states that the positive welfare implications that come from security of tenure are one of the most common findings recognized through multiple studies and surveys, which include reduced levels of stress and depression. I know that this government has been working on the mental health strategy, and I think that was something that's been supported by all parties in this House. I think it's really good that there's a mental health strategy, and we're working towards addressing that. And I do know that the mental health strategy takes into account the social, the determinants of the social determinants of health. So my question is, has the minister or the department quantified the impacts of no-cause evictions and the government weakening security of tenure on mental health, and what the detrimental impacts that might be on depression? Because the RIS explicitly states the positive welfare implications that come from security of tenure. And it also explicitly states, if you look at the impacts that this legislation, that there's a risk that it will increase the rate of emergency housing or social housing. And we know that it will definitely reduce the security of tenure. And I know that there is a section here that that there's some recourse that tenants might have around retaliatory notices, and we'll get to that later. So again, restating my question is that if your intention wasn't to kind of bring immigration to the issue of the housing stock at all, because they're kind of unrelated concepts, why did you mention it in the first place? What was the kind of rationale behind that? And what is the minister? What is the quantification of the no-cause evictions and the government weakening security of tenure on mental health and depression? We already know that these services are under severe pressure, and in many ways are lacking. And I know that there's a mental health strategy that's kind of been drafted in place, and I know that resources are being progressed to address that. But if there's no quantification of them, or if there's no wider analysis that's been actually done on them, why has the government been so comfortable in making these changes that are likely to exacerbate the risks to mental well-being around New Zealand? And I think we have to acknowledge that I think mental health is a challenge that successive governments have not risen to the challenge on. And I know that there is a cross-party plan to kind of work on it together, and I think that's one of the best ways we can get enduring change on mental health issues in the House. But it just seems like actions like this, which the government's own explicit advice have said that it'll weaken tenancy security, and therefore reduce the positive welfare benefits of secure tenure. Why are we proceeding with this in the first place? Thank you.
Mr. Chair. The Honourable Tamapōtaka.
Mr. Chair, appreciate the time just to stand and make a couple of comments, and I just want to address the observation that perhaps my name is on the door of xenophobia, and the innuendo that's been introduced in some of the observations in Hansard today, and just to reject that innuendo. The comment that I made is that rents and supply can be affected by a number of factors: wage growth, cost to build, immigration. A whole range of things can influence supply and can influence rents. So that's the context in which it was made, and we got a little bit of a run on what the implications or consequences or interpretations of that might mean. In relation to tenants and retaliatory notice provisions in the RTA proposals actually give tenants a little bit more assurance that they can't be removed from a tenancy for enforcing their rights. And the bill will do this by expanding the retaliatory notice provision to include a notice given by a landlord in response to enforcement action taken by a personal regulatory body such as IMBI, repealing the 28-day time limit for tenants applying for an order that a termination notice was retaliatory, and of course misuse of termination ground is an unlawful act that may result in a $6,500 penalty. The additional item that I thought it would be useful to mention is just around that tenants who want to terminate a periodic tenancy will be reduced back down to 21 days from the 28 days that it's currently. And this actually, in our view, provides a little bit more flexibility for tenants. But thank you for the other comments that were made, and I was invited to make a response by the member for Manurewa, Mr. Chair. Just that if I was in a situation, I was a developer, and I wanted to build some rental apartments or some rental houses, but I know that I have no flexibility if I am the landlord around no-cause terminations, that, in the view of the government, is a disincentive to actually build those houses or those apartments. And that's the sort of context in which we view these. Again, the government is very, very clear that we want to ensure that there's the right balance and flexibility for landlords putting on rental arrangements, and to ensure that these sensible and considered changes are made in alignment with our coalition arrangements, and of course trying to ensure that there's a better housing system in place. Kia ora.
The Honourable
Mr. Chair, I spoke a little bit to the disclosure, the departmental disclosure statement with respect to Māori, and I know that Tamitha Paul has spoken about this, but I have a couple of questions. So if we turn to the regulatory impact statement and the Treaty of Waitangi analysis of the termination proposals, it's really clear that it will negatively impact Māori for a number of reasons, and I won't traverse that all again. But the point that I think is of note is that the Waitangi Tribunal has indicated that where disparities exist, active intervention may be required by the Crown to remove those disparities. It is likely these proposals will raise concerns and criticism from the Waitangi Tribunal in relation to the risk they result in further inequities, Article 3, the lack of consultation with Māori, and consistency with the principles of partnership, participation and action and active protection. I think this is big. And I want to know from the Minister how he thinks that a policy like this that has that type of description about it, how a policy like this is therefore conducive to good Crown Māori relations. Mr. Chair, I'd also like to know from the Minister why he has chosen to actively reinstate the disparity, given that it was only a few years ago that we took this away, so that it made it ensured that landlords couldn't enforce no-cause terminations, Mr. Speaker, and now he's reinstating the disparity that clearly disproportionately impacts Māori. So there are two questions there related to the Treaty of Waitangi and to Māori, and I'd really like an answer from the Minister.
Just before we take the next call, I do note that there has been the Minister has addressed some of the broader questions that are being asked as well, and if I could ask members to make their questions specific to clauses in Part 2, that would help the House. Arena Williams.
Right, thank you, Mr. Chair. I'll set aside my notes on the economics of this change and focus now on clause 17, which inserts a new section 43AA. This is the provision that clarifies the extent to which a tenancy agreement may prohibit smoking in...
That's in Part 1.
Sorry, Mr. Chair.
Mr. Chair. Ricardo Mendes-March.
A line of the bill found in clause 22, stop clause 2, then line B, I was asking about line A beforehand. I think these deserve separate scrutiny because they're actually quite different ways in which a landlord can actually kick someone out way earlier than 90 days. The previous question I asked was in relationship to a family member moving in. And it seems to me that the minister confirmed to me that there's nothing stopping a landlord from literally lying and saying to a tenant, I've got a family member moving in, that may never eventuate. Someone's tenancy gets basically ended in 42 days and someone's life gets turned upside down, or that somebody's family member just moved in for a day or a week. So I'd like some confirmation of that. The online B, though, what I am referring to, which is my new point, is the line that says, the owner is required under an unconditional agreement for the sale of the premises to give the purchaser vacant possessions. It is our view that tenancies should transfer to a new owner, and where a landlord doesn't actually have to sell the property with a vacant possession. It's often considered that those properties may be worth a bit more. And I wondered whether the minister did any analysis of exactly how much more those properties are worth when they're vacant as compared to otherwise, and compared that with the impact and the negative impact of someone's tenancies being terminated as a in 42 days in this case, as a result of this. And I say this because this is a genuine issue. This has been raised in the People's Review of Renting. We had people who talked about, quote, I usually need to move house every 12 months due to landlords selling the house I live in to realize their capital gain. And I continue quoting, this has happened 3 years in a row, and it costs me upwards of $1,100 for moves and cleaners and uses up my annual leave. Emotionally exhausting. No security at all when renting. And this is why I asked this question. We do know from tenants about what this specific line, B, found in clause 22, will cause to them. And therefore, I think the onus needs to go back to the minister, because he claimed to care a lot about facts, to actually tell us what robust analysis has been done in terms of ensuring that actually this provision doesn't create financial hardship, stress, as has been identified by tenants in this People's Review of Renting, compared to, for example, the additional capital gains that a landlord or a property investor will be able to make by having a property being vacant when trying to sell. Because I'm worried that this isn't substantiated. And for somebody who's been criticized, well, several of us been criticized of just putting it out their opinions, it seems to me that he wasn't able to substantiate line A in clause 22, subclause 2, and I'm really curious to know whether he can substantiate with facts why was this line put in when we do know from reviews that it has caused harm to tenants. I recommend, if the minister hasn't read the People's Review of Renting, which was launched in 2017, that he does so, because he'll find plenty of robust analysis from people who have experienced these policies about what the specific line in the legislation will cause. And I do want to signal to the chair that I do have other questions, particularly in, if I move to clause 24, that are yet to come. So that's clause 24, subsection 2, A and B. But I'm hoping that the minister will address my comments and questions in relationship to clause 22.
Chair, and it's interesting listening to the debate this morning, and I'm going to speak on section 24, but I did want to make one brief comment before I jump into that, and it was the previous address by the minister around, making it easier for developers to build, and certainty for them, and the fact they can kick people out whenever they want and do whatever they want. But I think we've got to consider firstly a mindset change here, because in New Zealand this thing, it's this owning rental properties is this investment, whereas in Europe, it's a home for life, right? So we've got to, I challenge the minister to really consider the fact that, it's a mindset shift in terms of what actually being a good landlord is. So that's just a comment, but I'll move to section 24 of part 2. And this is around the replacement. So section So it's to replace section 54, where the tribunal may declare retaliatory notice of no effect. And so this replaces section 54, where the tribunal may declare notice around retaliatory issues. And so I think, we're considering this. I think this is something, because this is important. And so I guess my question is around, do you feel like the settings are right in this section? If I go to 54, or 54.2, the tenant may apply to the tribunal for an order declaring that the notice was retaliatory, or either or both of the following, on either or both of the following grounds, and it goes on with A and B. And I think we're being thoughtful around this, because I think this is the issue and the power imbalance of tenants and landlords, is that there can be things done and issues created, and then retaliating in terms of, and the power imbalance means that the landlord obviously has all the power, whereas the tenant has less power. So we think this, it could be okay, but we just want to get assurance from the minister he feels this is tight enough. I note that in number 3 of this, there's the tenant is able to make an application within 28 working days after receiving the termination notice, and the tenant may at the same time apply for an order declaring the notice to be of no effect. And then of course it's around what the tenancy tribunal then engages and does. So it saddens me that we even have to have the conversation about what landlords may choose to do, but it is, I think this part actually is potentially around the protection of the tenant. So do you believe that, does the minister believe that he has got this right, that it's tight enough, and then it has good checks and balances to ensure that the tenant is protected when it comes to retaliatory, I can't even say the word, but retaliatory and just meanness from the landlord?
Madam Chair.
Honourable Tama Potaka.
Thank you again for the opportunity to have a brief korero on this matter in relation to the question that was just asked regarding the retaliatory provisions, and we do believe that there is a strengthening of the notice provisions in the RTA, giving tenants a higher level of assurance in relation to the notice periods and the comments made around the notice periods for vacant possession. There already exists one of those, and it's for periodic tenancies. Of course, with fixed-term tenancies, that's slightly different because tenants continue to stay on. But for periodic tenancies, that notice period in the proposed legislation reduces from 63 to 42, and we believe that's a better balance and a sensible change. And in addition, where family members move in, whilst there was an implication from the comments around landlords potentially lying, there's also a requirement that family or whānau members that move into a home stay for at least 90 days. And of course, if not, then there's potential to give rise to a tenancy tribunal matter. Kia ora.
I'm going to take a call from Ricardo Menendez March. Could you refer to some questions you had around clause 24 if they are different from the questions that Glenn Bennett just asked?
Well, there are several amendments we haven't had a chance to speak either. So
I'm suggesting that it be specific to the point. It's not always on every bill that every amendment gets spoken to, because there's been lots of chances to do that. So stick to the clauses. If you want to bring an amendment into those clauses, then that's fine.
I appreciate that. And if you check the Hansard, beyond the stuff that one of the previous chairs, Greg O'Connor, talked about the broad economic settings, 2 of my other calls have been incredibly granular about the clauses that I'm referring to. So I hope some grace is given in relationship to that, and that I'm doing my best to pinpoint where I'm talking about in the bill. I want to talk about one of our amendments around the limit of the number of times no-cause evictions can be used for. This particularly relates to actually several provisions in including in Clause 24 around the retaliatory way in which these no-cost evictions are used. And the reason for that is that, as we identified in the debate around Clause 22, some of the provisions actually allow for some retaliatory methods to be used by nature of just a landlord lying, for example, around a family member, and then that actually leaving very little room for the provisions in Clause 24 to take effect, particularly around line A and B and sub-clause 24, Clause 24, sub-clause 2, A and B. The amendment that we've got would restrict the number of times a landlord can use no-cost evictions to 3 times a year. This is because in the analysis that we've heard from tenants, we've heard from some tenants that no-cost evictions had in the past been used multiple times a year for people. And so I wonder whether the minister had, particularly when it comes to the provisions in Clause 24 to protect tenants against retaliatory measures, but how those interact with actually other parts of the bill, whether he gave any thought to the number of times no-cost evictions should be used in a year. Because actually, if we go back to some of the provisions I was speaking to in Clause 22, there's so many days in a year that you could, if you divide it by 90, but because some of those provisions allow for 42 days to be given, you could have a landlord literally using no-cost evictions several times a year. So our amendment would actually put some protections in place to ensure that no-cost evictions can only be used by a landlord 3 times a year, which we don't nonetheless believe it will mitigate all of the harm, but it will go some way towards addressing what I believe is a lack of answers and even addressing from the minister from the questions I asked in relationship to Clause 22. So when he refers to the retaliatory issues, that actually leaves a gap, because I feel like he's going back to Clause 24 when I ask questions about Clause 22, but actually those are quite different issues. And so I wanted to understand, and I do still have more questions on Clause 24, but I did want to make sure that we brought our amendment. And there's many other provisions in the bill in Part 2 and several clauses that are yet to be addressed. But I did want to check whether the minister had considered whether there's a balance to be struck here and the intent he's trying to achieve, and then the number of no-cost evictions that can be executed by a landlord.
Madam Chair.
Honourable Willie Jackson.
Chair, and really pleased to take a call on this. And I realise, Madam Chair, that there are some areas that may have been traversed, but I need to, particularly with this minister in the seat, traverse some of the impacts for Māori on this. And so obviously I'm talking about Section 22, Clause 1, where a landlord may terminate a periodic tenancy in any case by at least 90 days. And as I said, I do appreciate that there's been some areas that have been traversed in terms of Māori, but we have to ask today, particularly given the climate at the moment, Madam Chair, what this minister in particular has done in his relationships. What has he done in terms of his relationships with Māori? I appreciate he has got quite a wide brief in terms of what he's doing in terms of Māori development and
I think the questions to the minister should relate to the clauses in the piece of legislation.
I was coming to it, Madam Chair. I just talked about the clause, and I'm talking about Part 3, Clause 3.1. What steps have been taken to determine whether the policy to be given effect by this bill is consistent with New Zealand's international obligations, Madam Chair? So HUD considered this bill, Madam Chair, and is it consistent, it's 3.2 I should say, consistent with government's Treaty of Waitangi obligations? HUD has considered the impact of the proposed bill through a Treaty of Waitangi lens, Madam Chair, including discussions with HUD's legal team and Māori policy team, and HUD also consulted with Te Puni Kōkiri during the policy development. And so there's a bit of an overlap here with this minister who has Māori development and iwi relations, and of course this particular kaupapa. And we always say that Māori development goes across all the different portfolios, and the good thing about this, Madam Chair, is we have a minister who has an associate housing responsibility. So I would like to know from the minister what type of what type of kōrero has gone down with him and Māori, not just mana whenua, Madam Chair, not just with mana whenua, but with our different Māori providers around the country. Has he signalled, and is he looking to work in coordination with some of those Māori providers, which is incredibly important at the moment as we have the whānau ora, as he well knows, the whānau ora kaupapa is now being put up by this government and being tendered for, Madam Chair, by many organisations, not just Māori organisations. So coming back to this point 3.2.
Can you just refer us to the page? We're just having a task finding.
I think I'm on the right bill, but I'll come to you. I'm talking about page 12, clause 22. Clause 22, point 1, a landlord may terminate a periodic tenancy in any case by giving at least 90 days notice. And what I'm talking about here...
Oh, right, okay. Now
yes.
you're talking about 3.2.
That's right, yes.
Right, okay.
That's right. And I'm talking about but no problem to clarify, Madam Chair. Anything else you want to clarify? Or?
Yeah. No
problem.
Thank you.
But I'm happy to clarify and continue talking about this kaupapa because the ramifications for Māori are huge, and I can see the Minister thinking about this, whether he's actually consulted with any Māori with regards to this kaupapa. Now, we know he has a relationship with iwi chairs, but there is some kōrero on the street, Madam Chair, that he has forgotten to speak with Mātāwaka and some of the key providers here. No, this is important for the other side because the Māori rate has dropped in terms of housing ownership, which this Minister is in charge of. In terms of rentals, Māori are transient, they're moving from house to house. Now this 90-day clause, as he well knows, threatens to put so many Māori out on the street. What is the plan around that? What are the treaty ramifications? Should Māori be scared because, Madam Chair, this government is proceeding with this treaty principles legislation? So what are the effects in terms of our different communities going forward? Can I ask him, has this been part of any kōrero with the whānau ora kaupapa, for instance, which is a major kaupapa at the moment because the government, everything is whānau ora, but I'm happy to explain this to members over, particularly to my good friend over there, Dana Kirkpatrick. Yeah, so very happy to take another 5 minutes, Madam Chair, to explain the consequences of this decision in a whānau order sense, Madam Chair. So this kaupapa has been put on the floor, Madam Chair. Madam Chair, I'm very happy to continue, Madam Chair.
Vanessa Wening.
I move that debate on this question now close.
The question is that debate on this question now close. All those in favour say aye. Aye. To the contrary, no. The ayes have it. The party vote has been called for. Please, Clerk, conduct the party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
ACT, New Zealand.
11 votes in favour.
New Zealand
8
First.
votes in favour.
Te Pāti Māori.
Ono ngā pōti e whakahe.
The ayes are 68, the noes are 55. The motion is agreed. The question is that Timothy Paul's amendment to clause 22 set out on AP number 226 be agreed to. All those in favour say aye. Aye. To the contrary, no. The noes have it. The party vote has been called for. Please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT, New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Ono ngā pōti e whakahe.
The ayes are 55, the noes are 68. The amendment is not agreed. The question is that Timothy Paul's amendment to clause 22 set out on AP number 227 be agreed to. All those in favour say aye. To the contrary, no. No. The noes have it. Party vote is being called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Ono ngā pōtea whakai.
The ayes are 55, the noes are 68. The amendment is not agreed. The question is that Timothy Paul's amendments to clause 22 set out on AP number 228 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote is being called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Ono ngā pōtea whakai.
The ayes are 55, the noes are 68. The amendment is not agreed. The question is that Timothy Paul's amendments to clause 22 set out on AP number 229 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote is being called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 votes opposed.
New Zealand
8
First.
votes opposed.
Te Pāti Māori.
Ono ngā pōtea whakai.
The ayes are 55, the noes are 68. The amendment is not agreed. The question is that Timothy Paul's amendments to clause 22 set out on AP number 230 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote is being called for, please, Clerk.
New Zealand National.
Oh, sorry, 49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā pōti whakai.
11 votes opposed.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Ono ngā pōtea whakai.
The ayes are 55, the noes are 68. The amendment is not agreed. The question is that Timothy Paul's amendment to clause 24 set out on AP number 231 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote is being called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā pōti whakai.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Ono ngā pōtea whakai.
The ayes are 55, the noes are 68. The amendment is not agreed. The question is that Timothy Paul's amendment to clause 24 set out on AP number 232 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote is being called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā pōti whakai.
ACT New Zealand.
11 votes opposed.
New Zealand
8
First.
votes opposed.
Te Pāti Māori.
Ono ngā pōti e whakai.
The ayes are 55, the noes are 68. The amendment is not agreed. The question is that Timothy Paul's amendments to clause 27 set out on AP number 233 be agreed to. All those in favour say aye. Aye. To the contrary, no. The noes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā pōti whakai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
Ono ngā pōti e whakai.
The ayes are 55, the noes are 68. The amendment is not agreed. The question is that part 2 stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumārima ngā pōti whakahe.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
Ono ngā pōti e whakahe.
The ayes are 68, the noes are 55. The motion is agreed. Members, we now come to part 3. This is the debate on clauses 30 to 39, tenancy tribunal and administrative matters, and schedules 1 and 2. The question is that part 3 stand part. Honourable Kieran McAnulty.
Thank you very much, Madam Chair. My question relates to clause 31. 3. This touches on the jurisdiction of the tribunal. I note that there are 2 other parts to that which other members may wish to explore, but I'm keen to understand the rationale for this. It specifically states that the tribunal does not have jurisdiction to determine a dispute so far as it raises a question as to whether, in respect of a tenant who gives notice accompanied by qualifying evidence under section 56B. Now, this relates to family violence. I had hoped to be able to ask questions about that in the previous part, but I also note that there are quite detailed provisions in Schedule 2, so we'll get into it then. Now, look, I've been very critical of the government's approach in Part 2, and I was very disappointed and said as much with the Minister's answers. But we had a very constructive conversation in Part 1, and I hope the Minister takes these questions in that vein. It's a very serious issue, and I'm taking it as such. I just would like the Minister to explain why these disputes are outside the jurisdiction of the tribunal. And I get that there's provisions outlined in this bill in other parts, but I'm not traversing that, Madam Chair. I'm just purely for context, that outline the process by which a tenant is to provide qualifying evidence to this. But my concern with this is that what happens in a scenario where a tenant provides qualifying evidence and that is disputed by the landlord? That is a dispute. And what this is saying is that the tribunal does not have jurisdiction to determine that. Now, there may be a reasonable explanation to this, and if there is, that's all good. But if there isn't, I think that is an oversight, because what we're talking about here is the ability for people who have been a victim of family violence or their dependent has been a victim of family violence to have special provisions available to them. Now, we fully support that, absolutely. In fact, we think that there were grounds for it to be stronger, but nevertheless, we support it. So we're not disputing that, But I'm concerned that those special provisions available to people in those horrific circumstances, if a landlord declines or dismisses the evidence that's provided, where does that leave them? So the landlord could say in that scenario, no, you don't qualify, or I don't accept the evidence, or whatever. That becomes a dispute. And the tribunal is there to address that dispute. But if it's not in the jurisdiction, where do they go? Now, we mustn't forget the circumstances that bring this about. And like I say, there may be a reasonable explanation, and if there is, fine. But I would like the Minister to take this seriously. It's a question in good faith, and not just cover it in high level, but actually answer it for the benefit of the House.
Madam Chair.
Aruna Williams.
Thank you, Madam Chair. My questions also relate to clause 31 on page 15, but they're a bit different in nature. It would be helpful if the Minister could give the House a little bit of context about these provisions here in the context of the legislation that changes the jurisdiction of the Disputes Tribunal having been passed after the Select Committee was able to consider these changes. Those two things interrelate because the programme of work to improve court timeliness that was begun by the Labour government and really helpfully, I think, picked up by this Justice Minister, changes the way that lower tribunals are intended to deal with lower order disputes and that more disputes will be handled by those tribunals. So the intention for the piece of legislation about the Disputes Tribunal is that more small claims will be able to be heard there. And in this piece of work, there are none of the same sorts of provisions to essentially allow more sorts of disputes to be heard by the Tenancy Tribunal. I want to know why that is and whether the intention is for some claims to be heard at the Disputes Tribunal level that would have in the past.
Sorry to just interrupt the member, but I don't want to have to ask you to say that again, but the Minister was taking advice, and I think they're important questions. We'll start your time again so that the Minister can
Apologies.
No, it's not a problem, Minister. You need to take your advice, but I was just concerned with the level of questioning that it wasn't heard, so if the member could start again. Apologies.
Thank you, Madam Chair, and fair enough too. I'll ask them in a different way so as not to bore my colleagues listening along intently. One specific question is at page 16, clause 2, creates a new 7AA. This new 7AA, for instance, Minister, has a limit of 100,000 in instances like these, which is not a new limit. My question about asking the Minister to compare these provisions with the provisions of the legislation which has recently passed in the House to change the financial jurisdiction of the Disputes Tribunal is that is it the intention that the Tenancy Tribunal would be able to deal with more sorts of low-level claims like this in a more timely way? And I think that's probably yes, in which case why isn't the $100,000 limit higher? Because that limit effectively means that the High Court or the District Court is the court after the Tenancy Tribunal. So a District Court would have to consider a claim that was above the 100K limit. And that seems to be going in the opposite direction of the other changes to the tribunals at this level, which have been made by Minister Goldsmith, which are intended to capture more of these lower order disputes. The next question is about the change in the Disputes Tribunal legislation, which was intended to allow an order made by a referee in that jurisdiction to require a respondent to pay the cost of the filing fee of a successful applicant. So that's a new change at the Disputes Tribunal level. Why didn't the government consider that change or changes like it, which essentially allow a referee more tools in the toolkit to award costs and different sorts of costs against a party who is found to be at fault and might, in the opinion of the referee, be using the tribunal vexatiously to pursue a claim against either of the other parties? is it because in the housing context the government deemed that not to be appropriate, or was it because simply that piece of work that was happening at the Disputes Tribunal had not been considered when this piece of legislation was drafted? I asked the ministers that because that is a useful change at the Disputes Tribunal level. It means that applicants are less likely, they will consider carefully whether the costs that might be awarded against them in all sorts of circumstances. That those fees are usually pretty low. They can be between, I think it's $59 to $249. But for a tenant, that might be a significant amount of money when the sort of award that might be made against them. In a pet bond context, I think the average award that was awarded in the financial year to the end of June 23 was $400. So we're talking about a reasonably substantial fee there. Why would we not make a change here where, in the opinion of each individual referee in each individual case, there was an ability for costs to be placed on the party at fault, or any of the other sorts of costs that you might anticipate in a housing context. Ricardo Menendez-March pointed to a number of other costs which are associated with a tenancy dispute. That was in response to the Minister previously and the Chair talking about the kinds of situations where you don't want to get into a tenancy dispute, you don't want to be in the tribunal in the first place. And though we all agree with that, there will be lots of disputes which come out of this, which result in situations like Ricardo Menendez-March has spoken about, where people lose their wages, where people lose their time, where people are not compensated for time off work. Those are all costs which are harder to quantify, but then there are a number of costs which are easy to quantify, like the filing fee, the cost of travel, things that you might, in certain situations, want to award against a vexatious litigant.
Ricardo Menendez-March.
Madam Chair, so if I refer to clause 31, subclause 1, and then to subsection I and subsection 2. I wanted to, I guess, just get a sense of the implications, and we do have an amendment to address this, the implications of, I guess, the double dipping when it comes to the pet bond and the general bond. I think this is quite concerning because it's like we have this whole narrative that the government's created around, like the purpose of how people are going to enable pet bonds to then allow pets to more easily cohabitate with tenants on their property. But the way that this is written, in my view, prevents the ring fencing. It prevents the ring fencing, which I think is really, really problematic, because effectively what it does, it allows landlords to dip into either bond, the general bond or the pet bond, to try and literally maximize profit when somebody's exiting a tenancy. I think this is quite problematic because it could end up resulting in landlords trying to find ways in which the amount of money that they want to claim back from the general bond is high enough that it exceeds it, that they know that they can tap into the pet bond to make up for it, and that therefore the amount of money that landlords will try to recover will start becoming higher. We do have an amendment, and I'll just bring up the numbers so that we can be granular in this regard. It's Amendment 3234 under, I believe, Tamitha Pulse's name, that seeks to address this. And basically, our amendment, what it would do is it would be to ring fence it. So basically, not allow the general bond to allow to be dipped into to cover for example, incidents where landlord deems that the pet bond exists what was put in, and vice versa. I think this is really important because when we think about low-income workers, people on the benefit, etc., trying to access a tenancy, like saving for a bond actually requires multiple weeks of savings for people who are often living week by week. For people on the benefit, accessing assistance for bonds often comes as a debt. So we've got to remember that actually, like, this is not just money that many people won't be able to, well, that find it hard to access, but that they'll have to then eat away from their own weekly incomes to eventually cover. And if we have a situation where landlords are enabled to dip into either type of bond, and find basically as many excuses as they can to maximize profit, I think they will. The evidence has shown us that when landlords are given an inch, they will take a mile. Multiple reviews have shown us this, and I am concerned that the way in which Clause 31, Subclause 1, subsections 1 and 2 are written undermine actually the intent of being able to ring fence the pet bond and then actually have mechanisms in which we're just dealing with the issue of pets. If, in my view, landlords want to raise issues in relationship to the recovery of the general bond, that should stay within the limits of the general bond. We shouldn't be allowing landlords to dip into this otherwise. So I'm keen to understand what the rationale is to allow this, whether the Minister has any views about Tamitha Pulse's amendment to ensure that actually this can be protected, and whether the Minister had any analysis or in facts around the implications for tenants of potentially being able to access less of that bond as they move out of the tenancy.
Madam Chair.
Madam Chair.
Honourable Tamapotaka.
Madam Chair, thank you for some time to respond to specific issues raised by various members opposite in relation to this part 3. Just to note, one of the comments made by the member from Manurewa around awards through the tribunal process. If a party is successful, their filing fees can actually be awarded against the unsuccessful party. That's one pathway for an award that offsets things. The other item that was raised around the $100,000 threshold or current level for RTA disputes has been in place for nearly 15 years. So it actually was a bit ahead of its time, or ahead of the disputes tribunal anyway. There was a comment made by the member opposite, Member McNulty, around the provision around family violence, and it's actually quite tragic, some of the levels of family violence that are out there, in tenant arrangements and other arrangements. But it is the role of the tribunal, it is not the role of the tribunal to determine whether or not family violence has actually occurred. That's probably more in the criminal space. The tenant only needs to provide the qualifying evidence that it has occurred, and whether or not it has is the matter for another body. The commentary about the amendment paper that member Ricardo has mentioned, so the ability to use pet bond funds for other matters, in our view, improves the efficiency by avoiding situations where the landlord has to pursue money. Yes, and the member has voiced many of his own opinions today, are owed through other avenues despite there being untouched funds available, and a landlord would only be able to access those funds that are set aside on the basis of pet bonds for non-pet related damage or costs with the agreement of the tenant or by a tenancy tribunal order. This provides, of course, a little bit of flexibility for the tenant as well, but also encourages the expeditious payment of any costs owing.
Madam Chair.
Aruna Williams.
A quick question before I move on to section 35. The question that was put to the Minister by the Honourable Kieran McAnulty about family violence, this is an important issue, and we don't mean to ask trivial questions, but just to clarify what the intent was. With the qualifying evidence of that violence has occurred in a situation of a household, it may not be clear to the Tenancy Tribunal whether that meets the wording here that it is family violence. If violence between my boyfriend and I in the first 3 weeks of our relationship and living together has occurred, I can prove that to the Tenancy Tribunal, but I cannot prove that it is family violence. I also can't prove that if there is violence going on in my household between two flatmates, that is family violence. And so we're asking the Minister to clarify what sort of violence will mean that the Tenancy Tribunal automatically declines to hear a case and that there is no jurisdiction for the Tribunal. There will certainly be cases about this We're simply trying to draw out here what the intention is when Parliament sets down that family violence is one of the prohibited grounds. Should that be the meaning of family violence in another act? Should that be up to the referee in each given case to determine? Now, Section 35, this amends the provision in the current Residential Tenancy Act about facsimiles. It's useful to update that. The problem here is that it's not an equivalent. What we are replacing here is any electronic address. So in the current Residential Tenancies Act, if a tenant is served with documents through their fax, then they will receive that. You can only send a fax if the fax is plugged in and is at the number that it expects to be at. So that's envisioning a situation where in the household that you're trying to send a fax to, a printed out copy of the legal documents will appear in that household. That's what was intended in the original Act. What we've replaced it here with is any document transmitted to an electronic address. So what that means is that if I was to send Minister Paul Tucker a set of documents now via his signal or via text message, that would suffice for the definition that's set out at 35(8). It's pretty unusual. Usually service of documents in most courts is pretty clearly that in a way that the person is deemed to receive it. For superior courts, we're talking there about legal service, which is a profession in itself and regulated as such, where the person in charge of service is in charge of also being able to give evidence to a court that they did in fact give the documents to the person. That's probably not appropriate here because we do recognise that in these situations where pretty low amounts of funds are being contested and that we're in a situation where people have reached a dispute over many days, weeks, months of dispute, and there might be real issues with service if we were to require that level of service. But we still need some sort of level here that we think is appropriate. Sending a text message doesn't seem to be that. It's certainly not equivalent to the provision which it was replacing, which is a fax. So my question to the Minister is that, how can we be sure that we're not setting the bar so low that people can honestly not reasonably be expected to have read the documents that they are meant to have?
Honourable Damien O'Connor.
Look, thank you very much, Madam Chair, and I've just come down to the House to make a brief intervention in this really important piece of legislation. You know, someone's home is their castle. It is critical that we provide proper process, and in dealing with Part 3 of the bill here, to follow on from my colleague, the Section 35 does address the issue of email address and facsimile number and moves us forward into the new world, I guess, of electronic addresses. And then it deals and assumes, of course, and it's an issue for rural New Zealand, I know you will understand this, it assumes that, you know, everyone has access to kind of electronic communication instantaneously, every day, every minute of every day. Actually, the provisions here do work through the timing of the issuing of documents or the notification, and it moves us into the electronic world, and I think we all accept that you know, physical documents are no longer necessary, but it is important to know that at the other end, you know, that there is access, and in rural areas in New Zealand, for a number of reasons, often that is erratic. And so the question I have of the Minister is, was this considered and was there some flexibility? Because in reading through, I see no flexibility. Subsection 10 says, improving service of a document transmitted to an electronic address. It is sufficient to prove that the document was properly transmitted to that address. And we know often, and I certainly do, whether it's text or emails, sometimes you think you've sent it, and for some reason it hasn't gone. Now, it's a rare occasion, but it does happen that the server might have gone down. But more often than not, if there is a problem in rural areas, it is related to the capacity of the system or something that may have intervened in some way. So in asking questions around this Section 35, it is whether the Minister is prepared to have some flexibility in there to ensure that that wise adjustment, you know, if it's taking on board some of the realities of the move into the electronic world. It also makes provision for the interruption of what is a well-intended serving of notice, and that is the transmission of it. But actually, I think there should be in here some confirmation obligation or some ability to confirm so that actually the person receiving it can confirm it in a way. And I know that there may be some questions and say, well, the person doesn't want to confirm that, but actually there is an ability to confirm the receiving of that, and that should be written in here. This just says properly transmitted, and I think, and proof of acceptance or opening of that document. That can be done. Anyone now can ask of a provider. It's way beyond my technical knowledge, but you can tell whether someone has opened a document. And so whether that should be included or whether the Minister has asked or received advice on that would be something that I'd like perhaps he could clarify for me. Thank you.
Francisco Hernandez.
Madam Chair, I'm hoping to ask the Minister some questions around Section 33, around the decision on the papers bit. Now, I really want to ask, when does the Minister consider it may be appropriate for the Tribunal to decide proceedings on the papers beyond the limitations on subsection 2? But I also wanted to ask the Minister whether he or his officials had statistics on whether there's differences in outcomes on when a tenancy tribunal case goes to the papers, or whether it actually goes to the to an actual trial. Because I think it's really important that we make sure that in allowing the tenancy tribunal to hold decisions on papers rather than doing the full thing, that we're not contributing to that we're not creating barriers for justice, that we're not exacerbating any existing inequities. Because it would be a shame, for example, if the minister's officials had figures that showed that, for example, that Maori or Pacifica were less likely to win cases on papers, for example, and if we're moving to a system that does rely on decisions on papers, then that may contribute to exacerbating initial inequities, and I'm sure that none of us in the House would want to see that. And I think that is a broader concern that we have, that this does give the Tenancy Tribunal too much leniency on deciding whether proceeding on the papers is appropriate. Maybe there should be some sort of component on making sure that that the tenants are okay with that, because there is a kind of power differential in the situation. In most cases, not all cases, but in many cases, it's the tenants that will be the underdog in the situation, and it's especially true in not my electorate. I noticed that the Honourable Rachel Brooking is here, so I'll say that the electorate that I'm based in, of Dunedin, I think that's especially true in the electorate that I'm based in, of Dunedin, where there's a lot of the cases in the Tenancy Tribunal are from students who are renting for the first time. And I think that's a really tough experience for people renting for the first time, particularly for young people. I remember when I moved down to Dunedin when I was 16 years old. I was very young, wasn't old enough to actually legally drink, but I was old enough to be signed on to a lease for some reason. And I think the first flat that I was actually in, there was a flatmate who set up a meth lab in the flat. So I think that just goes to show the kind of situations that that young people can get themselves into, and the sort of inequities that might arise with tenants that deal with the situation. And we do have a suggestion that might address this power gap a little bit. Our amendment would require the tribunal to consider various factors in deciding if it's appropriate, so that the tribunal can give appropriate weight to the complexity of the case and other factors. And that amendment is, do you know what it is off the top of your head?
It's there.
It's there. It's one of these many amendments that me and my colleagues have.
235, we think.
Yes, great. thank you for the assistance, Madam Speaker. So I would hope that the Minister would consider that. I am keen on the statistics that are requested on the decisions, but I just wanted to, I guess, close my contribution by asking what the rationale for the changes. We know that the Tenancy Tribunal has been, well, as with the wider court system, been under considerable pressure over the past, just over the past decade or so. I think there's been a lot of things that are, and we know that there's probably going to be more cases going to the Tenancy Tribunal because of the changes that the government is making. Is the motivation just to make sure that that the courses can proceed faster through the Tenancy Tribunal? Is it because of resourcing reasons? And yeah, we really want to make sure that this is being done in the right way. And yeah, thank you for the opportunity, Madam Chair.
Madam Chair.
Honourable Tamapotaka.
A number of parts I have been asked, and very diligently and professionally, might I add, in relation to a wide gamut of issues in this part. Certainly the view of the government in relation to the qualifying evidence and family violence issue is ultimately the Tenancy Tribunal is not the right body to assess whether or not family violence has occurred. The mention of the facsimile actually gave me some serious flashbacks to the postal rule in a Laws 101 class about 30 years ago, and the main guy, John Miller, well-known lawyer, teaching us about that, and certainly respect the observations as being very genuine, but it is up to the tenant to advise whether or not the facsimile fax machine is a method in which that tenant is happy to be contacted. There are other options, of course, open to that tenant, whether or not that's be email or, of course, that well-known snail mail. There was some mention from the member, or one of the members from Dunedin, in relation to, I think, whether or not paper is being used as an appropriate method, and if have confidence in the expertise of the tribunals and the tenancy tribunals, but if the tenant can't represent himself or herself adequately, this would, I expect, be considered by any tribunal. Parties can also share their views on the hearing format. Of course, the Tenancy Tribunal, considering the matters on the papers, can help expedite the Tenancy Tribunal decision and also have an implication for the rent payable. The Tribunal has guidance available to them as whether or not they consider hearing a case on the papers or having an actual hearing in person. And certainly the comments by the members are well appreciated.
Honourable Rachel Brooking.
Thank you, Madam Chair, for an opportunity to talk on this Part 3 debate of the Residential Tenancies Amendment Bill. I just want to go to Schedule 2, which makes amendments to Regulation 9. And this relates back to what will be the new 56B, which is the withdrawal from tenancy following family violence, and talks about the notice being accompanied by qualifying evidence. So that's the key term here, qualifying evidence. And then what happens, I think, is that the regulation then specifies what the types of qualifying evidence are. And it's got an A, B, C and D there of qualifying evidence, a first page of a protection order at B, a police safety order at C, a charging document at D, or a written statement at A. That all looks on the face of it to be very sensible. I've got no questions about that. My only question on this is at 2, there's the phrase all or any. So it says the types of qualifying evidence, if notice is given of the Act, all or any of the following are, and it's that phrase all or any that I'm interested in. Why it's needed to be all or any, because that provides some subjectivity and some question if all of those different A, B, C, D are required, or any, meaning just one. So wouldn't it be better just to be any of the following, or one of the following, or the relevant of the something to suggest that it's the relevant document? Because I without going through exactly the differences between them, but presumably under whatever sort of violence was at issue, under B, C or D, there would always be the opportunity for a written statement at A. So there's always going to be an option of having at least two of the following. So then, does that mean that there will always need to be a written statement and one of the others? Or is it, should it be interpreted that it would be the relevant B, C or D, depending on the circumstances? So if the Minister could offer some advice on that, I think that would be helpful for the Hansard at least, but also if he would consider changing that all or any to be more specific, which could just be any if you deleted all or. If it's only one of those that is required, then to say any of the following. Thank you.
Ricardo Menendez-March.
Turning my attention to clause 34 around the section 91A, well, the parts that changed section 91A, particularly inserting subsection E and F. I'm really interested in, well, two parts around this. I have two key sets of questioning. The first one is around the communication by email. I'm really concerned about how this was written, because I think particularly in subsection F, where we're allowing for a landlord to basically take issues to the tenancy tribunal after 2 years that tenancy's been terminated, to use the email address that the tenant had used to communicate with the landlord or otherwise applied to the landlord in writing within the 2 years before the application. I think it assumes that people operate like, frankly, older generations tend to hold an email for decades. And that is not the case for young people, actually, and young tenants. Many young people actually don't tend to use the email address they had perhaps when they were 18 and carry that email forward into their, for example, 30s. I know that's the case for myself and many of my other millennial peers, as well as those people younger than mine. Because a lot of those emails that we create when we're 18 often, frankly, have quite embarrassing names, because we made them when we were young. But on a more practical level, I do think this actually poses a real question, in that how will the tribunal be able to determine that actually the former tenant had received those communications? Because one thing is to rely on an older email, and the landlord could say, well, that's the one email I had from, say, you know, could have been 8 years after the tenancy had terminated, but it may not be the email that that person uses. And that is in the same way people move addresses, they change phone numbers, etc. And I don't think former tenants should be under any obligation to notify their former landlords of changes to their email address. I think this is an incredibly impractical way of putting in place these provisions. The other one, I think, goes more to the core of this act of clause 34, which is why we need to have, why is it that we need to have, to give the ability for landlords to pursue issues with the tenancy tribunal more than 2 years after the tenancy had ended? What is the evidential basis that gave rise to this? Because again, the minister had talked a lot about, you know, how he wants facts rather than opinions, but actually, I don't think we've been given robust justification by the minister so far as to what is the evidential basis that should allow landlords to pursue issues with the tenancy tribunal more than 2 years after a tenancy had ended. And I say this because I think, A, we know that the tenancy tribunal already isn't the best way to address issues, but like if we start giving landlords the ability to pursue cases in this way, it could, A, clog the system in a way that it is deeply unhelpful, In a way, I think it prevents those former tenants to be able to have the evidence freshly available for them to defend themselves. But then if I think again at some of our most at risk of homelessness populations, low-income people, disabled people, rainbow communities, like if we're talking about people who've been transient for several years, it'll be impossible for those communities to adequately engage with the tribunal process. I just don't think there has been robust justification to add subsection F, and I don't think the way this is written takes into account the real-world implications, particularly for younger generations, around changes of email addresses over the course of one's life, and how the way that this is written basically makes it just so easy to assume for both the landlord but also for the tenancy tribunal that all it is required is to use a potentially really old email. So I want to test the minister's understanding of how this will work in practice. How will the tenancy tribunal actually assess that the former tenant had actually received the communication, whether they'll be expecting a reply of some sorts, and if they don't receive a reply, they'll just assume that that wasn't the correct email address. So I just worry that this clause 34 will just give way more opportunities for landlords to cause harm, to bring up grievances that are way older, and I just really need an evidential basis to give myself and the broader public the guarantee that this has been thought of in a careful and constructive way, because the rest of the bill doesn't seem that way, and at least I want clause 34 to be adequately justified in part 3.
Honourable Tama Potaka.
Madam Chair, just in relation to the matter raised around all or any, as you'd expect to interpret it, does not need to be all, but no concerns have been raised along the way in relation to this particular provision. No concerns have been raised by officials. In relation to the email issue that Member Menendez-March has raised, certainly there's flexibility for tenants to provide multiple contact arrangements, and I too have had the experience of having a series of emails where I've completely forgotten the passwords and am unable to access those, especially that tama_portuck@yahoo.com, gone, never to be forgotten. But certainly providing a bit of flexibility to the relevant authorities and or landlord around contact details is something that we would continue to encourage.
Members, the House is suspended, the committee is suspended until after question time today.
Thank you, Madam Chair.
Thank you.